speak?
Yes, please.
Okay, so how, once your commitment packages come back to corrections, you'll be sent to state prison. You'll be going as a hold to state prison with the hold for the state. And then once you finish with state prison, then you go to the state.
I understand. Thank you.
All right. Go ahead.
Now I have a motion that a habeas corpus motion that I'm putting in, so I'm gonna get that resolved while I'm doing my time. But thank you.
All righty then. So we're going to reset this on December 8th to make sure your sentencing paperwork is processed and then you're sent on off. But there is going to be that extradition hold against you, probably served at the end of your sentence. Okay. Thanks for your time.
Thank you.
Bye.
That's it for me. May I be excused?
Just make sure I say that. Yes, and I think that ends our extradition calendar. Now I'm thinking we will head to our local state of Florida warrant calendar. And first individual we have on the calendar is Jacqueline Chappell.
Coming right now, Your Honor.
Okie dokie. I presume by your outfit that you are a cowboy. You probably don't know that song, do you? A lawyer. And your case is on the counter. What? All right. Please holler at me when we call you up and we'll insult, ignore you in the regular course of business. Okay. All right then.
Your Honor, Ms. Chappelle is here.
Good morning, Jacqueline Chappell or Chappelle. It looks like there is a warrant for you that has been issued by Broward County. And Broward County claims that you violated pretrial services on one count of grand theft in the 3rd degree and one count of unlawful use of a name. And all darn it, but Broward County has issued the kind of warrant and told me that I cannot set any kind of bond for you. So now we have to notify Broward County that you're here and give them a certain amount of time to come and pick you up. Let me turn to Eric and ask him, how much time do we usually set on? 15? Okay. Well, yeah, I can read. I can be a judge. All right then. So I'm going to set it from report on November 24th and tell them they have to come pick you up on or before November 24th. Anything you need to ask?
Do you have any questions?
All right.
What happens after that?
We've sent you to November 24th, rate transport to make sure that they come and pick you up. And counsel, oftentimes they'll roll a bus from Broward County about once a week.
Yes, Your Honor.
All righty then. Thank you. Next up, I'm going to call the case of Juwan McGraw. Oh my.
Mr. Wilson, on that last lady, it looks like she may have some health issues. And I think it's a misdemeanor. If you want to reach out to Mr. Valcour, I think that would be okay.
Oh, absolutely.
Good morning, Mr. McGraw. It looks like there has been a warrant issued from Broward County, Florida for your arrest. The warrant was issued on August 26th for a, let's see, warrant in a misdemeanor case for trespassing in a conveyance. So Broward County has issued a warrant for your arrest. Looks like the warrant was issued on August 26th. I believe, let me double check with corrections, I think that there is a bond amount of $500. Does corrections agree or disagree?
That is,
Okay, so, you're with us, warrant's been served, the bond in your case that Broward let us set is $500. I'm going to set your case for report on November 24th to see if you are released from jail or if Broward County comes and picks you up, okay? All right then, thank you.
So November 24th, right?
What?
November 24th, right?
Yes, sir.
I'll be back in court, right?
Unless somebody bonds you out, and
It's $100. That's what it is.
Do my mom know?
I don't know, mom have $500? Anyway, if you are bonded out, it will be very important that you go to the Broward courthouse and find out what your case date is. So you don't get picked up again. So either stay in jail with us until the 24th. If somebody bonds you out, have your paperwork, call the Broward County Courthouse and find out when your case is set in court up in Broward again, so you don't get another warrant, okay?
Yeah, but I don't know how.
And let me call the case of Jamar Reed. Jamar Reed. Good morning, Mr. Reed.
Come on.
It looks like you've been picked up because Broward County issued a warrant for your arrest. They issued the warrant against you on September 17th. I regret to inform you that it is a no bond warrant, so this court cannot set any kind of a bond for you. The warrant has been issued in a case for a violation of probation. Looks like the case was battery and aggravated assault with firearm. So since there is a no bond warrant, Broward County will need to come pick you up. I'm setting your case on the calendar November 24th to make sure they come and pick you up. The bus usually comes down at least once a week, but we're going to set it on November 24th to make sure that you are held here no later than that. Any questions, sir?
Okay, so if they come before November 24th.
November 24th is the cutoff date to make sure they've picked you up by then. My best guess is you'll be out of here within a week, more or less.
Okay, I appreciate it.
Okay, then. Thank you for your time.
also, he is a VFOX. He's out on felony bond. Would that be no hold?
A felony bond in Miami-Dade County?
Yeah, he's out on felony bond, F251958.
Judge, I'm not asking for a hold.
I do not believe a no bond hold would be appropriate because it's a VOP, which may not be a new arrest. So I cannot put in a no bond hold. But to corrections, thank you for double checking with me. I appreciate it. And I'm next going to call the matter of Rick Mendoza Hernandez.
Honor, I believe you have a private attorney on form, Ms. Lana.
Good morning,
Cucciello.
Your Honor. Lana Cucciello on behalf of Mr. Mendoza.
Good morning. Have you had a chance to look at the paperwork?
Yes, Your Honor.
All righty then.
And I believe this is just an out-of-county warrant with a bond already attached. There was a need to hold for him to see a judge. So hopefully if there's no surprises, he can bond out today.
There's no bond.
Surprise.
Surprise. Your Honor, I was under the impression there was a $2,000 bond attached already.
So let's see. I have a bond of $2,000 in a couple of cases. A bond of $200,000. So, to corrections, where has the no bond hold come from?
Okay, so in the affidavit, it says total bond, no bond.
Judge, we're talking about who? Rick Mendoza?
Yes, Your Honor, Rick Mendoza. I'm sorry. ASAF, Rick Mendoza Hernandez.
Hold on, corrections. Let me read this again.
Uh,
I don't see
so
that. No.
$2,000 bond.
F, I think it'd be appropriate for me to mark in this case that
Wait, I think corrections just said something different. Corrections, it's 2,000.
And I'm trying, I wish the audio could help me because I've been trying to talk and I'm talking as loud as I can. You guys cannot hear me.
Okay, tell me, is it 2,000?
Yes, it's 2,000.
Okay, so Miss Lana, if you can't post it, if there's any issues, just log back onto Zoom, okay?
We will. Thank you so much.
So, as a final comment on this case, I'm going to mark on the back of the paperwork that the bond is $2,000. And Ms. Cucciella, if your client is able to make the bond, please assist him in getting in front of the Monroe County Court so this matter can be resolved, all right?
Yes, Your Honor, we will.
And in the meantime, let's set this report on November 24th to make sure your client does not slip through the cracks, all right?
Great.
Thank you for your appearance.
Hopefully we won't see you then. Thank you, Your Honor. Thank you, ICF. Have a good morning,
And
everyone.
corrections, MFF, thank you for helping the court square this file away. Now let's call the matter of Laura Bloom or Blum. Laura. Good morning, Ms. Blum.
Morning, Your Honor.
It looks like DeSoto County, Florida has issued a warrant for your arrest. They issued the warrant back on March 19th of 2025. Regretfully, this is a no bond warrant, so I cannot change that status. It's a charge of fraudulent use of personal ID victim, somebody either 18 years or younger, or somebody 60 years or older without their consent. So since there is a no bond status, we're going to let DeSoto County know they must come pick you up. They should pick you up before November 24th. And I'm setting it on the calendar to make sure that takes place. Do you have any questions you need answered this morning?
Yes, ma'am.
What?
I had a case in Dade, and I have to be in court on November 24th.
You on what date?
November 24th. So
No-
do I call my attorney or?
November 24th is the very outside date here. They should pick you up on or before that date. If they had not picked you up on or before November 24th, then it would be possible that we would have to release you unless there are extenuating circumstances. So that's why we set an outside date of November 24th or whatever date is appropriate. Most likely, DeSoto County will pick you up before then. Okay?
I'm gonna have a case.
Right, so Judge, if she's in DeSoto County, and she can't come to her hearing in Miami, she should let her attorney know she's in custody.
Yep. Okay, then. So now I think we've exhausted the fugitive hold calendar, and I'm looking forward to looking at the felony paperwork for the morning. Thank you. Now, for corrections, if you don't mind, I'm going to call out of turn a case because I have counsel in the courtroom and I always like to get rid of them as soon as possible. I'm calling the case of Roel Cruz Carcamo. Carcamo's case was on or about page 10 of our morning calendar.
Good morning, Judge. That's happening on his behalf.
And let's get Carcamo an opportunity to join us in some fashion. Have you, sir, had a chance to examine the A forms?
Yes, Your Honor.
Okay, then I will waive reading it
Spanish
for you.
please.
He has a hold for immigration.
Oh,
He does.
Spanish interpreter, please.
Present, thank you.
Mr. Carcamo, good morning.
Buenos días, señor Carcamo.
It appears
Acérquese al micrófono, por favor. I just want to get closer to the mic.
I have a lawyer in the courtroom who's here on your behalf.
Un abogado está aquí presente en la sala de juicio representándolo.
And you are being held on a charge of workers' compensation of fraudulent activity.
Y el cargo que enfrenta es por actividad fraudulenta en lo que tiene que ver con compensación de empleados.
Any argument on probable cause, counsel?
No, Your Honor.
Probable.
El abogado no tiene argumento para motivo fundado.
Judge, standard bond is fine.
And the standard bond in this case, I believe,
All second-degree felonies are 7,500.
Ambos son delitos mayores en segundo grado. La fianza es de 7,500, la fianza estándar.
I will issue the standard bond of $7,500.
Entonces, dice la juez, emitiré la fianza estándar de 7,500.
On the other hand, at this time, the immigration department has put a hold against you.
Por otro lado, tenga presente que usted tiene una orden de retención migratoria.
And that means that even if you paid the bond, you would not be released from custody because of the immigration hold.
Lo cual significa que así usted pague la fianza, igual no va a ser puesto en libertad debido a esta orden de retención migratoria que tiene.
I'm sure your lawyer will talk to you in the next couple of days about what all's going on in the case.
Estoy segura que dentro de los próximos 2 días su abogado va a hablar con usted en cuanto a lo que está pasando en su caso.
Yes, Judge, I'm already in contact with his immigration lawyer. This is going to be a PTI offer, so we're trying to figure it out.
Ya el abogado está hablando con el abogado de inmigración. La oferta va a ser un programa de intervención previo al juicio.
Okay.
Okay.
Excellent. To correction, I am going to call out of turn a case on page 7. And that will be the matter of Lewis Mack.
Your Honor, he's out on probation, F10 32300.
Is that for private counsel, Judge? Rebecca Corey, Assistant Public.
It was, I called it out of turn because I have family members in court for Lewis Mack.
Thank you.
And let's see.
Waiting. Judge, he's not available this morning. He should be available in about 5 minutes or.
Okay. And since he's still being moved to get to the camera, I'm gonna put this to the side and call it back up, but we'll of course let Mr. Mack know that you're here. And I'm gonna put this back to the side. And I'm going to, let's see, look on page 13, out of turn for family in court. Let me just check with corrections and see if you have available Dexter Roundtree. If you do, you do. If not, I'll keep it in mind. Sometimes people can be brought up quickly. Sometimes it takes a while. So let's corrections check and see if Roundtree is available. Are you Mr. Roundtree?
No.
Dexter?
Yes, ma'am.
Well, good morning, Dexter Roundtree. It looks like you have been arrested for a search warrant was issued on November 6th. And during that arrest, it looks like you were arrested for cocaine possession while in possession of a firearm, possessing cocaine with the intent to sell it, selling cocaine within 1,000 feet of a protected zone, armed possession of marijuana with the intent to sell it, and trafficking in cocaine. So these are the 5 charges for which you have been arrested. Let's see what we can do to start setting bonds. Let me start with the state and see what their position is for an appropriate, I can see that on count 5, standard bond would be $2,500, but on counts 1, 2, 3, and 4, let me start with the state loudly, clearly, telling me what you believe the bond should be set.
$5,000 on counts 1 through 3. So that would be splitting the standard bond for a first-degree felony. $5,000 on count 4 is fine. So $5,000 on everything except for count 5, $2,500.
So count 1, 5,000. Count 2, 5,000. Count 3, 5,000. Count 4 was 2,500.
It's marijuana. That's fine.
Couldn't hear you, F.
That's fine. $2,500.
So for corrections, that's 5,000, 5,000, 5,000, 2,500, and 2,500. The court having read the arrest affidavit and found probable cause. Now, let me stop. Can I answer any questions for you all? Nothing?
I'm trying to see what's the total in the bond.
You could take 20,000.
3 is 15, that'd be 20,000.
Your Honor, you said 4 and 5 is 2,500?
Yes. Anything else? Well, thank you for your time this morning. Sorry to be the deliverer of bad tidings, but there we go. Okay.
Thank you.
And let me return this to you. And for it now, oops. I think I'm gonna go back. Ooh, we have a busy week. I call. Thank you. Can you remind me of your name? Eva, Victoria. Glad to meet you. Thank you. All right. To corrections and staff, I'm going to bounce to page 20 on beat. No, page 6 on beat phone. Case number 20. Looking for Jorge Valdez.
Morning, Your Honor.
Morning.
It's Real Lindsay Notes. I'm here on behalf of Jorge Valdez. Good to see you, Judge.
Good to see you. I guess the rumors of my death were premature. Have you had an opportunity to read the arrest affidavit?
Yes, I have.
Okay, gotcha then.
And Judge, pretrial is fine, and if counsel wants a bond, that's fine too.
Spanish interpreter, please.
Good morning, Mr. Valdez.
Buenos días, señor.
Buenos días.
I have a lawyer in the courtroom appearing on your behalf.
Hay un abogado aquí presente en la sala de juicio que está representándolo.
Probable cause is found on the drug arrest case for possession of cocaine.
Hay un motivo fundado en el caso que tiene que ver con tenencia de cocaína
And possession of drug paraphernalia.
y por tenencia de parafernalia para drogas.
I think I heard a suggestion that pretrial services with alternate bonds is appropriate. Is that correct, Ms. F? I see your head popping up and down. Okay. Pretrial services, alternate bond in count 1 is 5,000. Alternate bond in count 2 is 500.
The judge for non-violent third-degree felonies, standard bond is 2,500.
Entonces, me pareció haber escuchado que le ofrecen el servicio previo al juicio, entonces queda autorizado para el servicio previo al juicio como alternativa. Para el primer cargo, 5,000 de fianza, para el segundo, 500. Y dice la fiscal, señoría, la fianza estándar para delitos en segundo grado son 2,500.
So, in count 1, pretrial services, alternate bond 2,500. In count 2, alternate bond is $500.
Entonces, pues, servicio previo al juicio y como alternativa 2,500 en el primer cargo, 500 en el segundo.
Yes, I just have one concern that I want to see if we can expedite. He's leaving the jail. He is a heart transplant patient, and worse, he had very drastic aortic surgery. I had aortic surgery.
Anyway.
And it's very dangerous. His blood pressure last night went to 194.
Entonces dice el abogado, señoría, hay una cosa que me inquieta, es que me...
You want the interpreter to interpret. Go ahead.
Tiene una condición al corazón y tuvo una situación con una arteria, la presión arterial estuvo muy alta, anoche estuvo a 131, and we continue, counsel, thank you.
Your Honor, my surgeon told
And
me to keep my blood
counsel,
pressure very low.
I am going to order pretrial services to take Mr. Valdez.
El abogado le voy a ordenar al servicio previo al juicio para que se encargue del señor Valdez.
So I am ordering him into pretrial services.
Le ordeno que vaya al servicio previo al juicio.
Dottie. All right, let's get two verifiable references up and on the record and on the A form. Your handwriting might be better than mine.
Entonces necesitamos un par de información para verificar.
All right, let's take our time and get names and phone numbers for these folks.
Entonces le pidieron los números de teléfono para verificar esa información.
Need the address, relation.
Lo siento, señor. Espero que en pocos minutos habla con ustedes, familia, en la corte.
They also have a list of all the medications.
Well, it ain't good Spanish, but it's kind of Spanish.
You did pretty good, Judge. You did pretty good.
French was my major. So with Mr. Baron, I have signed an order asking pretrial services to get you out of jail today.
Entonces ya firmé una orden para que pueda salir de la cárcel hoy mismo bajo el servicio previo al juicio.
We are verifying some family members' addresses in court right now.
Ahorita mismo en la corte, en sala abierta, están verificando la dirección de familiares.
I've signed an order for your pretrial release and given it to your lawyer.
Ya firmé la orden para su escarcelamiento, para que sea puesto en libertad y se la di a su abogado.
So we are hoping that you will be released from jail in the next couple of hours.
Entonces esperamos que lo pongan en libertad, que lo suelten de la cárcel durante las próximas 2 horas.
Any questions?
¿Alguna pregunta?
Me? No.
Bye. On air. Now, I am going to move the normal calendar, if there is such a thing in this building. Calling the matter, Lakeisha Williams.
Your Honor, we have Mr. Mac Lewis.
Let me move to that file. Thank you for pulling somebody out of turn for me. So we bounced back to, I think, page 10 or 20, calling the matter Lewis Mack. Good morning, Mr. Mack.
Good morning.
You do have family members here on the courtroom in your behalf. So let's see what we have here, Ms. Curry. I did appoint the Office of the Public Defender for the purposes of this morning hearing, and it looks like your client missed a re-registration in October as a sexual predator. So an affidavit has been filed claiming that your client failed to register during October. Hearing no argument, probable cause is found. And I think we have a complicating factor here, Ms. Curry, and that is that your client is on probation with Judge Altfield in felony 10-32300. Now, when this happens, I will be issuing a no bond hold and setting this case immediately in front of Judge Altfield, most likely on Monday or Wednesday, so Judge Altfield can revisit the issue of the probation violation. May I answer any questions for you all? You gotta speak loudly. I was playing percussion last night and my ears are still ringing.
Wife passed away. He was working hard and he had time, he forgot. And he's supposed to have the funeral on the 15th.
On when?
The 15th. They set the funeral for the 15th.
They'll see Judge Outfield before then. Set report. Eric, can we get a date in front of Outfield maybe on Monday? All right, so the judge, and I don't remember what floor Judge Outfield is working on, do you? So we're going to set this for case Monday morning in front of the Judge Outfield. And
it's on the 6th floor.
Yeah, and to have Judge Outfield visit the issue of no bond hold on the probation. And see if and remind Judge Outfield about the funeral and that type of thing, okay? All righty then. Set for report on, that'll be 11. If today is the 7th, that'd be 8, 9, 10.
The bond?
There is a no bond on this case. Yeah, let me set a standard bond of $2,500 into corrections. Thank you for reminding me to do that. And just gonna tag a little no bond hold on F10-32300 set for report in front of Outfield on 11/10.
Your Honor, a quick question. So how does, because this is new for me, how does it work with the bond? You mentioned.
She shouldn't, don't post the money unless you know that the probation hold is going to be lifted. If you post the money
if you posted the money today and then Outfield didn't let him out on Monday, then you'd be out the premium if they charge you a processing fee type of thing.
Okay.
So I would sit tight until Monday. My best guess is Outfield will probably work with you on the felony probation, but he may not. I can't make him do anything.
Okay.
So we'll set on Monday morning. Don't spend any money until after the case is called and you figure out which way it's going.
Okay.
Okay. Anything else? And I'm sorry for your loss in the family.
Just 2 private attorneys who are waiting on Zoom. I don't know if you want to take those out of turn.
Oh, great. Okay. So, Curry, I'm old and people. How do I figure out who's waiting to be called?
So we have Gustavo Torrealba, number 23 on page 7.
Okay. I'll go to page 7. And I've made a couple of smarter young people co-hosts if you want to pull up whoever's waiting.
And then the other private attorney that's waiting is for client Anthony Boyd. He's number 43 on the calendar on page 12. If there's any other private attorney waiting, please type in the chat who you are here for. And I know Mr. Martin.
Okay. Be right with you, sir.
Spanish interpreter.
And we have Mr. Barón helping us out this morning.
Good morning, Honor.
Good morning, sir.
Se presenta el abogado.
Mr. Torrealba.
I am calling this morning the case of Gustavo Torrealba.
Señor Gustavo Torrealba.
And is there counsel representing this gentleman?
Daniel Lurvy on his behalf.
Acaba de presentar el abogado defensor.
Good morning, Mr. Lurvy.
Good morning, Judge. How are you?
Have you had a chance to read the arrest affidavit yet or not?
I have.
Okay.
El abogado ya leyó el informe del arresto.
Judge, I know it's a burglary with an assault. I had sent a email to Ms. F.
Señoría, yo sé que es un ingreso ilícito con intento de agresión.
I was hopeful that she may agree to a bond. He was doing a little self-help, going to get his tools from somebody that he knows. He was allowed in, and then, at worst, it was a push and shove.
Entonces él estaba haciendo un trabajo por cuenta de él, le dejaron entrar y en lo que se entiende hubo una situación donde hubo un par de empujones.
I'm told he has no priors, but I have not been able to confirm that.
Él me dijo que no tiene antecedentes penales, pero todavía no he podido verificar eso.
He knows the alleged victim. His wife, who was with him, is the real estate agent who rented the, studio to the alleged victim. and my client loaned him some tools and then went back to get them, and that's when the pushing occurred.
Entonces él conoce a la presunta víctima, la esposa es la agente de bienes raíces que estaba ahí, le había prestado unas herramientas, regresó y ahí fue cuando ocurrió la situación.
Certainly the type of matter that in division they ultimately will stipulate to a bond. I hate to make them sit waiting for an Arthur hearing.
Entonces, este tipo de situaciones, yo sé que pudiera aprobarse una fianza para que no tengan que esperar ahí, esperando una audiencia para ver si le autorizan excarcelamiento.
That's all.
Sería todo.
Miss F, were you feeling inclined to stipulate to the court ignoring the non-bondable status and setting a bond?
La juez pregunta si de hecho es una situación en la cual pudiera presentarse a que no haya fianza.
Judge, counsel's right. I don't see any criminal history. And I see that counsel's right. I don't see any criminal history. And I see that the defendant's 61, but there is probable cause. I'll leave it up to you, Judge.
Señoría, si el abogado tiene razón, no hay antecedentes penales, el acusado tiene 61 años, pero hay motivo fundado, lo dejo a su discreción, señoría.
Judge, I'm pretty certain that a stay away order will be sufficient. He's a legitimate guy, hardworking. He's from Argentina originally, has lived here for decades, has a wife. I'm not certain if he has any children, owns property, and with a stern warning of the court not to go back to that location or to have any contact with the victims will absolutely suffice with whatever monetary bond the court thinks is appropriate.
Señoría, yo pienso que la orden de alejamiento sería suficiente. Él es un hombre que trabaja duro, él es de Argentina, él tiene su esposa, no estoy seguro si tiene hijos, tiene propiedad acá. Yo pienso que es suficiente con una orden de no regresar y que se mantenga alejado de la presunta víctima.
F, it could be my ears, it could be the fact that your speaker is fuzzy. Was that you will allow the court to set an appropriate bond, thumbs up, or the court?
No, up to you, Judge.
All righty then. So in this matter, I'm going to make a finding that Mr. Torrealba, I'm going to set a bond for you.
Señor Torrealba, voy a fijarle una fianza.
But there are some conditions of this bond that you are going to have to follow.
Pero hay unas condiciones que usted tendrá que seguir para que se haga esta fianza.
You are prohibited from having any contact with Lucas Alvarez or Vladimir Sanchez.
Usted no podrá tener ningún contacto con Lucas Álvarez ni con Vladimir Sánchez.
This means in person, directly or indirectly.
Eso significa ni en persona, ni directamente, ni indirectamente.
In writing, by telephone, pager, or fax.
Ni por escrito, ni por teléfono, ni por fax, ni por pager.
You cannot contact these people through third parties.
Usted no podrá contactarlos tampoco a través de terceros.
You must stay at least 500 feet away from the alleged victims.
Y en todo momento tendrá que mantenerse por lo menos a 500 pies de distancia de las presuntas víctimas.
Their home, their place of appointment, and or any other place you might encounter them.
Donde estas personas vivan, donde trabajan o en cualquier otro lugar donde se las pueda encontrar.
You cannot have any electronic contact such as emailing, texting, social media, twittering, twerking, any of those things.
No podrá tampoco contactar a estas personas por ningún tipo de medio electrónico, ni por redes sociales, ni por texto, ni por Twitter, ni por nada de eso.
And you must stay away from 2050 Southwest 22nd Street at all times.
Y en todo momento tendrá que mantenerse alejado del 2050 South de la 22 Street en todo momento.
Mr. Lurvy, you're the moving or the begging party, as we might call it. What bond would you suggest? And then we'll give the state an opportunity to respond.
Entonces estás preguntando la jueza al abogado que sugiera que se haga a continuación.
Judge, I would request a $10,000 bond from my understanding of his financial wherewithal.
Señoría, yo pediría una fianza de $10,000.
Without waiving any objections to the court setting a bond, Ms. F., what is your reaction to $10,000?
¿Qué piensa la fiscal de los $10,000 de fianza?
I think it's reasonable.
Es razonable.
Bond is set at $10,000. A stay away order has been issued and read.
Entonces se ha leído la orden de alejamiento, la fianza queda $10,000.
Anything else, Mr. Lurie?
No, Your Honor. Thank you very much for your time, and thank you, State. Have a great day, everybody.
¿Algo más? No, no hay nada más.
Now, I'm hearing I had another case, Mr. Anthony. Oh, you are so good. Lucky me. And now to corrections. I have moved out a turn off page 53 to a Anthony Boyd Jr.
Your Honor, we have to go pick him up. We don't have him.
All right. To counsel who's waiting for Anthony Boyd, corrections understands we're looking for him, and as soon as he is available, we'll call him back up.
Okay, thank you, Your Honor.
All right. Now let's see. I will return to the calendar. I have a case of Leticia Williams, who is not brought to court today. Let's see.
Ms. Corey, you want to have the judge set a bond?
Was found yesterday. Now what?
Yes, correction, she's not here today?
She's not brought to court today. She wasn't brought to court yesterday when probable cause was found and the public defender was appointed.
Waiver presence at this point, Judge.
All righty, then it's a firearm possession by a convicted felon. Any suggestions from the state on what bond they would like to see?
5,000.
Defense? 5,000 it is. Thanks for coming. Next up, we have the matter of Heather Lindsay. Good morning, Miss Lindsay. It looks like you were arrested yesterday for stealing from the Family Dollar store, and they are claiming that you have 2 or more prior convictions, so now the petty theft is considered to be a felony. Ms. Curry, any argument on probable cause?
Not on probable cause, Judge. I would ask if you would consider the TAP program. Ms. Lindsay is homeless. The value is $10.05.
The judge state's issue is that she came in on a bench warrant. She's got a 30-day sentence from about 3 weeks ago, and she has other prior arrests, convictions from this year. I don't know if Ms. Corey wants to see if she's eligible for a hospital, but the state is requesting a monetary bond.
Back to you, Ms. Curry. Final thoughts. Ms. Curry, here's my finding. Probable cause is found. If your client did not have an outstanding warrant already, I would consider the program you asked for. But with an outstanding warrant, I am uncomfortable with that request. Thus, I'm setting bond in the amount of $500, and let's get your client in front of that misdemeanor judge and see if we get some things resolved.
Judge, Miss Lindsay has no money. She just indicated she does have benefits. Could we try to see if we can get her into the hospital, Judge? Could we reset her for the afternoon? I'll reach out to Southern Winds Hospital to see if they will accept her benefits and get her transferred to the hospital for treatment.
I'll be here this afternoon. I will cross out the $500 bond, reset it to the afternoon calendar, and talk to you this afternoon.
Thank you.
That gives me something to look forward to already. All right, let's put this in the afternoon calendar file. And I think I have now the file of Catalina Valenzuela Alvarez.
Your Honor, we have Mr. Boyd.
All righty. If you want me to call Boyd before Alvarez, I'll be glad to, since you've gone to the trouble of it, of course. Anthony Boyd Jr.
Good morning, Your Honor. Anthony Frank on behalf of Mr. Anthony Boyd.
All righty. Good morning, sir. It looks like we have counsel appearing on your behalf, so I'm not appointing the public defender to represent you at this time, since you have counsel making an appearance. Counsel, have you had an opportunity to read the arrest affidavit or not? I can read it to you if you hadn't gotten a copy.
Yes, ma'am. I was able to pull it off the online document.
Okay, good. The miracles of fiber optics. Any argument you have on probable cause?
Yes, ma'am, Your Honor. In this case, the actual victim has an active warrant out of Miami-Dade stemming with the defendant. And I believe this case was brought up because of that issue. Because he was in the process of going to pick up his child from Georgia, because the victim herself does not even live in the state of Florida. The house, I guess he was picked up by Homestead PD. That house was sold 2 years ago.
So
and
I
like I
was
said,
wondering if you had an argument about the
yes,
sufficiency of the four corners of the document without
yes.
introducing
Mhm.
testimony that's not in court, you know?
Yes, ma'am. Like I said, I don't believe that there's probable cause just based on the facts and understanding that's listed in the probable cause affidavit.
So Judge, I'm not sure I understand
The
counsel's legal
court
argument.
finds probable cause from the four corners of the document. Now, I can set an appropriate bond, and of course, Mr. Franklin, I'm sure you're aware of setting further bond review proceedings in front of the trial judge. And
Okay, thank you, Your Honor.
I'll start with the state. I have two counts here, one of battery by strangulation, and then a misdemeanor domestic violence. On count 1 and 2, let's hear what the state is recommending.
All right, so Judge, this did occur in 23, but it was reported contemporaneously as indicated by the police case number. I don't see any other criminal history, but this is extremely violent. The victim needed to be transported to the hospital. My office did speak to the victim, who indicated that she is afraid of the defendant, wants to make sure that Your Honor order that the defendant not use or possess any firearms, and is seeking the stay away order. State's request would be the standard bond, which would be $5,000 on count 1, $1,000 on count 2.
Back to you, Mr. Franklin.
Yes, ma'am, Your Honor. He's a lineman for the FPO, and he's been working there for 20 plus years. I'm also joined. His mom is on the Zoom hearing with us right now. I'm going to request that the bond be reduced in the court's discretion. I know it's a standard bond, but if the court can reduce that bond amount, that would be great.
All right, so Mr. Boyd, and a bond will be set. So if you're able to make the bond, you'll be able to get out of jail. But there are some conditions that are going to apply to your staying out of jail. You cannot engage in criminal activity while out on bond. You cannot use or possess illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms and ammunition that you own and any concealed weapons permit to the nearest police department and file a receipt with the court. Do you understand those conditions, sir?
Yes.
You are prohibited from having any direct or indirect contact with the alleged victim, whose initials are B.S. You cannot be in contact in person, in writing, by telephone, through social media, or any other electronic means. You cannot contact this person through third parties, and you must stay at least 500 feet away from the alleged victim, their home, their place of employment, and or their school at all times. And I'm going to ask your lawyer a question. Mr. Franklin, are these co-parents?
Yes, ma'am, they are.
All right. I'm making a finding that the protected party is have a child in common. Mr. Franklin, is there a visitation type arrangement?
Not at this moment. I don't know, Your Honor. No, I haven't been able to speak to
All
my
right.
client about that.
You will need to work with your client, Mr. Boyd. I don't know if you're actively having visitation with the child or children, but if you are, you and your lawyer will need to arrange some type of drop-off, which involves you not having any contact with the alleged victim until the court can sort this out. And is that something you understand?
Yes, ma'am.
All right. Now, Mr. Franklin, your client and the alleged victim are not currently living together?
No, ma'am, they are not.
All right, then there's no request for visitation. So, and Mr. Franklin, is your client involved in any kind of hearings in dependency court or dissolution court?
No, ma'am.
All righty then. So those are the conditions of the release. On your case, I have made set bond in count 1 in the amount of $5,000 and count 2 in the amount of $1,000. We've made the note on the jail card. Mr. Franklin is going to assist you with those matters. Can I answer any questions for you, sir? Okay, just checking. Thank you for your time. And thank you for your
Thank you, Your Honor.
Franklin.
Thank you, guys.
Yes, ma'am. Thank you, Your Honor. Have a great day.
Alrighty, so now we have a file for Catalina Valenzuela Alvarez.
She's a bond out?
All right.
She had a fugitive, corrections, are you sure? She had a fugitive hold and an ICE hold, I thought.
What?
So if corrections could just make sure she bonded out.
If she had a bond on her future, she can.
Okay, just want to make sure.
I'm not sure. Sure. Your Honor, these are added charges for Ms. Suarez.
What happened to
Bond?
If y'all ignoring you all while I do some paperwork.
So there are 2 bond outs, right? Corrections?
Yes.
Got it.
All right, so in the matter of Valenzuela Alvarez, I made a note that case is bind out. Now I have Eleni Castaneda. All right, so then our next one would be Denise Suarez.
She's present.
All right, let me finish making a note on the last case and then we'll be right with you. Dextroamphetamine. So, Ms. Suarez, it looks like this is an added charge for, they're claiming that on October 11th, the defendant generated a strap tamper alert from your electronic monitoring device. They went to your last known address, found the monitoring device with a cut strap, and they claimed that you were absconding from the conditions of your release. And then they dropped the arrest affidavit on you. So this appears to be an added charge. I don't hear any argument on.
So Judge Glazer usually splits the bond, 2,000 count 1, 500 on count 2.
Correct.
And probable cause having been found, these charges have been sitting out there, so bond is set in count 1 for 5,000 and count
2,000.
2,000. You know, I wrote that down and said the wrong thing. 2,000 and count 2 is 500. So that was 2,000 and 500. Do you have any questions you need to ask us while you're in court?
No questions, Judge. Thank you.
All right, thank you. Now we're calling up the matter of Oscar De La Torre.
Good morning, Your Honor. Paul Diga on behalf of Oscar De La Torre from the Office of Joshua Alexander.
And it's Mr. Dig.
Correct.
All right. So I don't know if you've had a chance to read the A form. I can read it for you if you weren't able to get your hands on it.
No, Your Honor. I've read it and will stipulate
Okay, then.
this.
So probable cause is found. And the standard bond on this is $2,500.
Yes.
Judge, I do want to make an argument as it relates to that.
Okay.
Mr. De La Torre is not on active probation for the particular issue that he has to register for. He successfully completed his probation. He's been registered and reporting for many, many years. This is the first time he's had any violation as to that. And it's not for not reporting at all for the month. He just reported a few days late for the month. So based on that and based on his ties to the community, the fact that he hasn't had any significant any issues on his supervision for many, many years, I would ask the court to, and that he's of limited means, I would ask the court to first consider ROR, if not, at least issue pretrial release with the alternate bond in the amount that's standard.
Let's take sex offender registration. Oh, then, Ms. F, there has been a request for the court to either release him on his own recognizance or order him into pretrial services or set a standard bond. Which choice would you like the court to consider?
Maybe a slight reduction from the standard bond, 1,500. I don't see any prior violations.
We have option 4 thrown into the mix is a lower bond. Counsel, if I lowered the bond to $1,500, is that a bond your client can make?
It would certainly be more feasible for him. I would just ask Your Honor to still consider a pretrial release with the alternate bond in that amount of $1,500.
No, bond is $1,500, lowered at your request, significantly less than what should normally have been done because, well, Mr. D, you're just so persuasive this morning that I'll grant that part of the request.
Thank you, Your Honor. I do appreciate that. And
All
Mr. Schultz does as well. Thank you.
See you.
Take care.
Now I'm going to call the file of Ramon Shapiro. Morning, Mr. Shapiro. Looks like you're charged yesterday with allegedly committing an aggravated assault with a knife, to wit, a deadly weapon, and then 1 count of disorderly conduct or breach of the peace of the public. Give us a second here to see if there's probable cause or not. Yikes. Any argument on probable cause there, Ms. Curry?
No argument, Judge.
All right. So probable cause is found on both counts. And let's see, on the beach. So you are currently don't have a mail-in address, it looks like, Mr. Shapiro. Now, as we go forward in the case, Mr. Shapiro, I'm going to order you to stay away from the Generator Hotel at 3120 Collins Avenue in Miami Beach. I'm also ordering that you have no contact with the security guard whose initials are H.R. Do you understand? You must stay at least 500 feet away from HR and or the Generator Hotel. You cannot directly or indirectly or through a person or writing or phone or pager or emailing or texting or any kind of media, you cannot have any contact with that individual or that arrest, okay? All righty then. And so let's see, what else do I need to do here? Standard bond on count 2 is $150 and standard on count 1 is $5,000. Care to be heard, Curry?
No, Judge. Thank you.
All right, count 1, the bond is $5,000 and count 2, the bond is $150 with the stay away order. And please follow the stay away order, sir. Thank you. Now, let's see. Keep a piece of paper for notes. I next have a file, I believe, of Michael Malone. Good morning, Mr. Malone. It looks like it's been claimed that on November 6th, you were in possession of cocaine and resisted an officer but without offering to do violence. Let's see if there's any probable cause here or not. Let's see, snorting a white powdery substance in plain view. Police came up.
Your Honor, is he out on felony bond? He's a V farm.
He's on probation, I believe.
Case number?
Right, corrections, I think he's on probation in Palm Beach and Broward, not locally.
Okay, thank you.
Not on felony bond then. Okay. Anyway, back to snorting and running. Let's see. Search after arrest, brown leaf tobacco laced with suspect cocaine inside, covered behind our left ear. Currently on probation for a burglary, reference Palm Beach County Sheriff's Office. Let's see. Cocaine baggie under the floor mat, firearm center console, blah, blah. All right, so Ms. Curry, any argument on the probable cause thing?
No, Judge, thank you.
All right, probable cause is found then on both counts. And let's see, standard bond is usually 2,500 on count 1 and 500 in count 2. Any argument on that there, Ms. Curry? All right, standard count 1, 2,500, count 2 is $500, and your bonds are now set, Mr. Malone. Okay.
So 25 on count 1?
Yes, and 500 on count 2. And now we have the matter of Jesus Peña.
Spanish interpreter, please.
Mr. Peña, on November 6th, you're charged with being at Macy's. And let's see.
I'm sorry, Your Honor, what, Macy's, please?
Macy's.
Yeah, but what about it?
It was charged with petty theft and attempting to use an anti-shoplifting device.
Got it. Thank you, Judge. Señor, se le acusa de que el 6 de noviembre se hurtó algunos artículos de Macy's y también estuvo saboteando con un dispositivo antirrobo.
Let's see. Any argument on the probable cause thing there, Ms. Curry?
Yes,
La juez le pregunta a la defensa si hay algún argumento para motivo fundado.
All right. Probable cause is found on count 1 and 2. And now, let's see. You have a current mailing address, so I'm going to
So Judge, I don't know how long, I see no criminal history, but it's unclear how long he's been in Miami. Can we see if, how long?
Entonces dice la juez, bueno, hay que motivo fundado para dar 2 cargos. Pregunta al fiscal, señoría, veo que no tiene antecedentes penales, pero quisiera saber hace cuánto tiempo que está en Miami.
Happen with the sound. Wait, am I muted again?
We can hear you better now.
You can hear.
Yeah.
Okay, I've been trying to argue, but I don't know what happened with the sound.
We heard nothing. Start again, please.
To myself for quite a while, Judge. So with regard to probable cause, I do have a probable cause argument.
Okay, great.
Pliers is not an anti-shoplifting device, so at best count 1 would be probable cause for a criminal mischief.
Entonces, en cuanto a motivos fundados, haría motivo fundado para el delito de daño a propiedad.
But they were used to remove the sensors.
That's why it would be criminal mischief for damaging a sensor, but there's a special definition for an anti-shoplifting or inventory control.
Interesting. Let's find that statute and read it.
It's a mechanism or other device designed and operated for the purpose of detecting the removal from a mercantile establishment or similar enclosure or from a protected area within such an enclosure of a specially marked tag.
You make the interpreter interpret the whole thing.
Entonces, well, I mean, in that case, in that particular case, I might as well just, provide a summary, if that's okay with the judge. Señor, en este momento la abogada defensora está leyendo la parte de la ley en que especifica en qué consiste el delito de sabotear un dispositivo antirrobo. Thank you, State.
So in my opinion, the statute's not written that well, but I understand Ms. Corey's argument based upon the way the statute's written. How long has he been in Miami?
Dice la fiscal, esa es mi opinión, no estoy muy de acuerdo con la manera como queda escrito el estatuto, pero entiendo el argumento de la señorita Corey. Quiero ahora saber cuánto tiempo hace que vive en Miami.
Judge, he's been here in Miami almost.
I'm sorry, I haven't been listening to you guys for about 10 minutes. I'm looking up the statute because this is interesting, and I got nothing better to do today.
Entonces está revisando la hoja del estatuto.
And then actually focus on the keen legal argument I'm having here. 015 subsection 7. Let's see. Subsection 7, she says. It is unlawful to possess or use or try to use an anti-shoplifting or inventory control device countermeasure. And so then, Curry, where is the specific definition of an anti-shoplifting device? Do you know?
Están entonces hablando de lo que es la definición, según la ley, según el estatuto de la Florida, en que consiste un dispositivo antirrobo.
See, maybe at the beginning, merchandise.
Correct. In the very beginning of the statute.
Retail, farm produce, farmer, farm theft. Any mechanism or other device designed or operated for the purpose of detecting the removal from a mercantile establishment. And shoplift device, any item or device which is designed, manufactured, modified, or altered to defeat any anti-shoplifting or inventory control device. How interesting. So, Miss F, let me ask you this. Do you think flyers were designed, manufactured, modified, or altered to defeat, one of the store tag things?
En este momento la juez le quiere hacer una consulta a la fiscal en lo que tiene que ver la definición y el uso de este tipo de dispositivos.
I don't think that's why pliers were designed.
No, creo que para eso fue que fueron diseñados unos alicates, unas pinzas.
Miss Murray, it sounds as if sometime before this year has ended, you have raised a successful argument.
Thank you, Judge.
Parece que usted presentó un argumento muy exitoso antes de que se acabe el año.
You sound surprised.
I'm sitting here completely shocked. Probable cause found count 2, count 1, no PC, released outright.
Or criminal mischief for destroying the.
So you're arguing that the arrest affidavit makes out a criminal mischief?
Yeah.
Got it.
Damaging the sensor.
Entonces, hay motivo fundado para el segundo cargo, más no para el primero. La fiscal sugiere que se haya motivo fundado para el primer cargo en lo que tiene que ver con daño a propiedad o fechoría.
That would be a second degree misdemeanor. There's no value to any damage.
Lo cual sería un delito menor en segundo grado.
Anyway, so, Mr. Pena, it sounds like if you can make the bond I'm going to set, you will get out of jail.
Que señor Peña, pareciera, si usted puede pagar la fianza que estoy a punto de fijar, usted pudiera salir de la cárcel.
And you are ordered to stay away from Macy's in Doral.
Y se le ordena que se mantenga alejado del Macy's en Doral.
You understand that by court order, you are not allowed to go to Macy's in Doral anymore.
¿Entiende usted que por orden judicial ya no puede regresar a Macy's? ¿Entiende eso?
Was that a yes?
¿Eso qué quiere decir? ¿Que sí?
So, count 1 is a release outright, and count 2, your bond will be $150.
Para el primer cargo será un excursamiento directo, para el segundo su fianza será $150.
Yeah. And
Judge, would you consider
file for
would you consider pretrial services as an alternate for Mr. Pena?
No, thank you.
La abogada defensora le pregunta a la juez si pudiera tener en cuenta el servicio previo al juicio como alternativa. La juez le dice no, gracias.
He has no history, Judge, and he's been in Miami for about almost 2 years, going on 2 years.
Tiene historial y ha estado en Miami casi 2 años.
No, thank you.
No, gracias.
My next file will be that of Rome Mitchell Herrero.
Spanish interpreter, please.
Mr. Marrero, you're charged with tampering with the witness,
El Barrero está enfrente del cargo de sabotear a un testigo o de influenciar a un testigo,
strong arm robbery, and domestic violence battery.
de robo con violencia y también por agresión física con violencia doméstica.
Ms. Curry, do you have any argument on probable cause?
La juez le pregunta a la abogada qué argumento tiene para motivo fundado.
No, Judge.
Your Honor, he needs a
Mire.
Spanish interpreter.
Say what?
Does he need a Spanish interpreter?
Yes, the Spanish interpreter's been translated.
Okay. Probable cause is found.
Se haya motivo fundado.
Mr. Marrero, I'm going to issue a stay away order in your case.
Señor Barrero, en su caso, va a emitir una orden de alejamiento.
This means if you get out of jail, you cannot engage in criminal activity.
Eso significa, si usted sale de la cárcel, no podrá ejercer ningún tipo de actividad delictiva.
You cannot use or possess any illegal drugs.
No podrá estar en tenencia ni consumir ningún tipo de drogas ilegales.
You cannot use, possess, purchase, or carry a firearm, weapon, or ammunition.
No podrá comprar, portar, estar en tenencia ni usar ningún tipo de armas de fuego ni municiones.
You must immediately surrender any firearms, ammunition, or concealed weapons permit to the police and file a receipt with the court.
Cualquier arma de fuego que usted tenga, arma de fuego, municiones o cualquier salvoconducto para portar armas, tendrá que entregarlo en la estación de policía más cercana y radicar un recibo que le den allá ante el tribunal.
You are prohibited from having any contact with Janet Mayo.
No podrá tener, a usted se le prohíbe que tenga cualquier tipo de contacto con Janet Mayo.
No contact in person, in writing, by telephone, or social media.
No podrá contactarla ni ni en persona, ni por teléfono, ni por escrito, ni por ningún tipo de red social.
You cannot contact Mayo through third persons.
No puede tampoco contactar a Mayo a través de terceros.
You must stay at least 500 feet away at all time from home, place of employment, and or school.
Y en todo momento tendrá que permanecer por lo menos a 500 pies de donde esa persona viva, trabaja o estudia.
Do you understand these conditions, sir?
¿Entiende usted esas condiciones, señor?
Sí, correcto.
Yes, correct.
All right, then. Now let me return to the issue of setting a bond. A standard bond in count one is usually $2,500 with a to be set by the court in counts 2 and 3. I'll start with the state and see if they have recommendations, then I'll hear from the defense.
Entonces, la fianza estándar para el primer cargo serían 2.500. Vamos a ver qué recomienda la fiscal y después la defensa.
So Judge, it's the same factual basis for 1 and 2. So maybe split the bond, 2,500 count 1, 5,000 count 2, and then standard on count 3, 1,000.
Señoría, es la misma base para el primero y el segundo, la misma base real. Entonces, dejar el primero para 2.500, el segundo para 5.000 y el tercero para 1,000.
Ms. Curry, what thoughts might you have on this matter?
Judge, I would ask if you would consider 2,000 count 1, 5,000 count 2, 500 count 3.
La defensa está sugiriendo que por qué no está sugiriendo una cifra diferente para fianza.
Okay. Bonding count 1 is $2,000. Count 2 is $5,000 and count 3 is $500 with a stay away order.
Entonces la juez lo aprueba. Primer cargo $2,500, segundo, perdón, $2,000 para el primero, 5,000 para el segundo, 500 para el tercero, más la orden de alejamiento.
Next, we're calling the file of Stephen Triana.
Your Honor, the persons in jail are recommend please pass.
Can't hear you.
Corrections needs us to pass.
Pass Triana. Okay. Let me call the file of Lewis Harris.
He's coming.
Mm-hmm. Within 1,000 feet of a church or convenience store, and this site's convenience store. Oh, okay. Just reading stuff. Mr. Harris, you were charged with being in possession of cocaine with the intent to sell it within 1,000 feet of a convenience store. Any argument on probable cause?
Yes, Judge, I would ask that you only find probable cause for possession with intent for the cocaine, not within 1,000 feet of a convenience store.
Because
this does not qualify as a convenience store. There's nothing indicating it's a convenience store, and there needs to be certain hours that store must maintain. So without designating it as a convenience store and stating its hours, it would not qualify under the statute for the enhancement.
Huh. State?
Well, it does say the store is named Days All Night Store,
Uh-huh.
but I don't know if that's sufficient for probable cause. Would Your Honor just set the $7,500 bond, which is the standard bond for possession with intent?
Well, as we go forward, Mr. Harris, I'm going to order that you are no longer allowed to go to Jay's All Night Store on Homestead Avenue, and you understand you ordered to stay away from there.
Yes.
Okay, I'm going to set a bond in the amount of $500 on this charge.
Judge, $7,500 is the standard.
Oh, $7,500 on this charge. And there we have it. Probable cause found, lower count, and stay away order. Alrighty then. Now I'm going to call another file. That of, looks like Felix Sanders. Let's see, you're charged with being in possession of MDMA / ketamine, possession of cocaine, and possession of marijuana while boarding a Norwegian cruise line vessel. Any argument on probable cause there, Ms. Corey? No? Okay. Probable cause is found.
In terms of the bond, Judge, the defendant's got an address in Los Angeles. Additionally, he was arrested in Las Vegas, also for drugs. 1 second. And that was in May of this year. He's also got some priors out of California as well. State's requesting no less than the standard bond.
All right. And over to you, Ms. Corey.
One moment.
Let's see, on counts 1 and 2, those are the MDMA and the ketamine counts. The bond will be $2,500 on each count. On the cocaine possession charge, count 3, the bond will be $1,000, and on the marijuana charge, count 4, the bond is $500.
The marijuana, would you ROR state?
No.
Execute that much?
No. Anyway, because the bonds are now set.
Your Honor, for count 4, what was count 4?
That was 25, 25, 1, and 5. All right then. Next up, we have a file for Brian Marco. Mr. Marco, you're charged with possession of cocaine, possession of Adderall, and possession of Xanax, all on November 6th. And let's see, I was wondering, Ms. Corey, any argument on probable cause?
No, Judge.
Probable cause is found. No, let's see. Let's set some bonds.
I would ask for pretrial services for Mr. Marco. He's lived in the community all of his life. I see no prior withdrawals or convictions for Mr. Marco.
Well, that was the dismissal of the controlled substance in 2018, but that was a dismissal. Anyway, Ms. F, there's been a request for pretrial service with alternate bonds. What are your thoughts about that matter?
I think it's okay.
All right. Pretrial service, alternate bond in count 1 and 2 is, and 3 will be $2,500. So count 1, 2, 3, alternate bond is $2,500 each count.
And I think they would probably take him back into drug court if that's something he's interested in.
I don't know, it looks to me more like sales and use, but it's up to you folks. Anyway, pretrial services, alternate bond. And next file we have will be that of Floyd Pace. Let's see, in a Mr. Pace's case, Ms. Curry, I have received a motion for pretrial detention. Give me a moment to read it. Did you get the motion for pretrial detention,
Yes.
Ms. Curry?
Yes, I did.
Okay. Let's see. This is a capital felony, a life felony, or the felony of the first degree. So, Ms. F, you're arguing then that the court should make a finding that Mr. Pace is not entitled to a monetary bond. Is that correct?
Yes.
All righty. Give me a moment to read the arrest affidavit as well. Let's see. Bunch Elementary School yesterday. Pickup truck came out. Got the pickup truck. Let's see, 36 grams of fentanyl, 29 grams of crack, 50 grams of powder cocaine, 13 grams of MDMA, 12 grams of marijuana, and 1,673 grams of the oxycodone pills. A loaded pistol near the drug evidence. All right, I've read the arrest affidavit. Let me start, Ms. Curry, if there is any argument for probable cause.
No, Judge. I would ask if you would consider using discretion in setting a bond for Mr. Pace. I see.
Ms. F, I've read your written motion. Have you any further argument?
Requesting the court grant the motion.
then I'm going to grant the state's motion for pretrial detention pursuant to 907.041, and that means at this time, Mr. Pace, there is no bond. Yes.
Your Honor, that's a no bond on 134.
Yes. And we have a file of Carlos Rodriguez.
Your Honor, he's in detox, NBC.
In detox. Oh my goodness. Well, I'll mark NBC and set it for tomorrow. Would that be okay?
It'll be this afternoon.
Then I'll NBC this morning and I'll set for afternoon calendar. See how he's feeling. Oh my. You know, we have a file of Marcos Buono. Okay, it looks like you're charged with allegedly commit an act of grand theft vehicle on November 4th. I'm going to read the paperwork and see if there's a probable cause or not. Let's see. Ms. Curry, any argument on probable cause?
Yes, Judge. He started the first degree felony. There's no value, so it should be at best third degree felony.
I agree.
All right. Probable cause is found, but for grand theft third degree is what I'm hearing. And a standard bond on grand theft third degree is what? $1,000?
$2,500.
How much?
$2,500.
All right, a standard on motorcycle stealing is $2,500. Can it be heard with that?
I think it's appropriate in that his address on the A form is Virginia, and despite that, he's got some recent thefts locally.
Judge, he's been here 4 years in Miami.
Yeah, I see convictions for the last 2 or 3 years, so he's been here a while.
Would Your Honor consider pretrial services?
No, not with the Manassas, Virginia address and having under your argument lived here 3 or 4 years. So I'm going to set the bond in the amount of $2,500 and go from there. All right then. And next I'll call in the file of Tylon Fuller. Let's see. Tylon Fuller is.
He's next door. If we can pass him.
I'll put it in the next door pile. And then maybe Malcolm Bowe. Good morning, Mr. Bowe. It looks like there was an arrest for aggravated battery. They claim this happened on October 26th. Let's see. Arguing. Reading it for probable cause now. Ow, took off the toe. Ow. Goodness gracious. Any argument on probable cause?
So, Judge, it does not appear to be clear that the intent was to touch the lid with the door, like when he closed it.
Let me read it again with that in mind.
It says that the victim, I guess, was keeping the door open with her foot, and the defendant intentionally pulled the door on the victim. I guess so hard that it removed the tip of her toe. And then he said, "I'm gonna kill you, ho." So I think in context, it seems like it was intentional.
Then court finds probable cause for aggravated battery. Now let me set an appropriate bond. Let me start with the state and see what your argument is.
He's got pages of priors. Most recently, 49 days for battery on a detainee. He was sentenced to 364 last year. I see some domestic arrests as well. Requesting a bond standard 7,500.
And Ms. Curry, what are your thoughts?
Judge, Mr. Bo is currently not working. He's lived in the community all of his life. He does have a place to stay, so he cannot afford a bond, but he does have a place that he would be able to do house arrest. Would Your Honor consider house arrest for him?
And Ms. F, did you care to respond to that request?
Right, the state's requesting a monetary bond.
As a condition of getting out of jail, Mr. Bo, there are some court orders you'll need to follow. You cannot engage in criminal activity. You cannot use or possess illegal drugs. You cannot use, purchase, possess, or carry any firearm, gun, weapons, or ammunition, and you must immediately surrender any firearms, ammunition, or concealed weapons permit to the nearest police department and file a receipt with the court. You are prohibited from having any direct or indirect contact with the alleged victim whose initials are EW. This means in person, in writing, by telephone, through social media, or any other electronic means. You cannot contact this person through third parties. You must stay at least 500 feet away from the alleged victim, their home, place of employment, and school at all times. Do you understand those conditions that will apply to your release, sir?
Yes.
All right, then. I will consider house arrest with a bracelet. Is your client working, counsel?
No, Judge.
What?
No.
And then it'll be level 1. So since your client is not working, there'll be no reason for him to leave his house. So I'm going to order a level 1 house arrest, meaning you're home and cannot leave, with a alternate bond of $7,500. Do you have any questions about that, sir?
No questions.
All righty then. Next, I'm going to call the file of Inaki Olabari Warrega. Interesting. Good morning, sir. You're charged with 1 count of organized fraud, more than $50,000. Grand theft, 20,000 to 100,000. Computer offenses causing defrauding, trade secrets, embezzlement of, and these are the counts that have been filed against you. I'm going to give finish reading the arrest affidavit, then we'll get right back with you.
We still need Spanish, please.
Oh, golly, I am sorry.
I'm sorry, the interpreter was not aware.
So you're charged with organized fraud, 50,000 or more, grand theft of the 2nd degree.
Usted enfrenta el cargo de crimen organizado en cuantía superior a $50,000, también de hurto mayor en 2º grado.
Second degree felony using computers to defraud folks.
Judge, you said boats?
And third degree.
I'm sorry, Your Honor, did you say boats? To defraud computers, to defraud what?
People.
Oh, folks, okay, got it. También el uso de computadores para defraudar a la gente.
And a third degree felony of embezzlement of trade secrets.
Judge, for the interpreter, please, the third degree felony of what again? I missed the last charge.
Embezzlement of trade secrets.
Oh, got it. Thank you, Judge. Y el tercero, el cuarto, que es un delito grave que tiene que ver con la revelación de secretos.
Let me finish reading the probable cause affidavit.
Un momentico, voy a mirar el informe del arresto para mirar si hay motivo fundado.
All right. So, sir, if you,
Judge, can you inquire of Mr. Ola Baria Huegri if he has funds to hire a private?
Got it. You are charged with a number of serious felonies. Will you be hiring a lawyer to represent you?
Señor, usted enfrenta varios cargos de carácter bastante serio. ¿Usted estará o irá a contratar los servicios de un abogado particular?
Sí, si no tengo, sí.
Acérquese al micrófono, por favor.
Sí, sí.
Yes.
Have you spoken with the lawyer yet?
¿Ya habló con un abogado?
Sí, tengo un abogado.
Yes, I do have an attorney.
Could you tell us that?
Se llama Gonzalo.
Acérquese al micrófono, por favor.
Se llama Gonzalo, el abogado.
¿González o Gonzalo?
Gonzalo.
¿Cómo?
Gonzalo.
Gonzalez, that narrows it down. Did your lawyer know you were in court this morning?
¿Su abogado sabe que usted está compareciendo frente a la jueza esta mañana?
Yo pensaba que sí, pero parece que no.
That was my impression, but apparently not.
Well, I will not appoint the public defender. I'm just gonna find probable cause and set some bonds for you.
Entonces no voy a asignar al abogado de oficio, simplemente voy a hallar motivo fundado de fijar unas fianzas para usted.
Your case will show up in court on Monday morning.
Su caso irá frente a los tribunales, frente al tribunal el lunes por la mañana.
Let's see if I can find the name of the judge. Your case is going to be
no.
Vamos a ver si encuentro el nombre del juez ante quien va a comparecer.
Judge, what are you trying to do? Because I think he would be entitled to a bond.
I'm sorry, what?
Judge, I think he would be entitled to a bond if he's willing to waive his attorney's presence, or we can reset it so his attorney can be here.
Podemos reprogramarlo, de pronto esperando a que llegue el abogado, o de pronto se le pudiera dar fianza.
I was getting ready to set his bond. Is there a problem doing that?
Because you said something about seeing a judge on Monday. I got confused.
Can't hear you.
Your Honor said something about him seeing a judge on Monday, and I didn't understand.
I found probable cause.
Okay.
I told him I'm going to set a bond.
Okay.
And now I'm looking for the name of his judge, if anybody knows it. Who?
It's Judge Brinkley.
Oh, okay.
Va a estar frente a la juez Brinkley.
So if you have contact with your lawyer in the next couple of days, your case will be in front of Judge Brinkley on Monday morning.
Entonces, si usted puede contactar o ubicar a su abogado de aquí a los próximos 2 días, usted puede decirle que su caso va a comparecer, va a estar frente a la juez Brinkley.
Now, as you get out of jail, I have to tell you, You cannot have any contact with the alleged victim whose initials are AGP.
Si usted llega a salir, se le prohíbe que tenga cualquier tipo de contacto con la presunta víctima cuyas iniciales son AGD.
You cannot go near the Calamio restaurant at 4000 Southwest 57th Avenue.
What's the name of the restaurant, Your Honor, please? Paladillo.
You cannot reach out to those individuals at the restaurant directly or indirectly.
No podrá ir al restaurante Paladillo, como quiera que se llame, que queda en la 4000 Southwest 57 Avenida. No puede contactar al personal que trabaja ahí ni directa ni indirectamente.
In person, in writing, by phone, or any electronic means whatsoever.
Ni en persona, ni por escrito, ni por teléfono, ni por ningún otro tipo de medio electrónico en lo absoluto.
You have any questions about that, sir?
¿Tiene alguna pregunta al respecto, señor?
Gracias. Please.
Thank you.
Now let me return to the task of setting a bond. Be right with you. We'll set
Ya regreso con usted. Vamos a hablar ahora de las fianzas.
Count 4 bond should be $2,500.
Para el cuarto cargo, la fianza serán $2,500.
All right, I'll take a recommendation from the state on counts 1, 2, and 3.
Ahora, ¿qué recomendaría la fianza para la fiscal para los cargos del 1 al 3?
7,500 each. So that'd be a slight reduction. That would be a reduction on count 1.
7,500 para cada uno.
The bond in count 1, 2, and 3 is $7,500 and $2,500 in count 4.
Entonces, para el cargo 1, 2 y 3, para cada uno son $7,500 y para el cuarto son $2,500.
Can I answer any questions for you?
¿Alguna pregunta que le pueda responder?
No, thank you. Thank you.
No, thank you.
Thank you. Next
Gracias.
up, we have the file of Hugo Amaya. Oh, that's an interesting one. Let's see. Still reading the rest affidavit. Be with you in a minute. Right then, Mr. Amaya, do you have plans to hire a lawyer in this case?
I do not. I don't have. Well, yes, but I don't have money for. I guess I'm public dependent. Right? Is that what it is?
Do you own any property?
Do not.
Do you own a boat or a car?
I do not.
Are you working?
No, I'm not. I've been working about a
Hmm.
year.
Ms. Curry, it sounds as if this gentleman might qualify for the office of the public defender for the purposes of the hearing.
I agree.
So I'll appoint the public defender to represent them and this gentleman. And do you have any arguments as to probable cause?
No.
All right, then. Probable cause is found on grand theft in the third degree over $100,000, as well as the third degree felony of an organized scheme to defraud and a third degree felony of securities fraudulent transaction. The bond in counts 2 and 3 will be $2,500. And to the state, what is your argument as to what the bond should be and grand theft over 100?
So, Judge, I believe there's an attorney present on behalf
Oh my goodness gracious!
of
I
some
see
or all of the victims.
Sarah on the screen.
Additionally, I see some other victims who are logged on to Zoom. I don't know if they'd like to be
Sarah,
heard.
are you appearing in this case?
Good morning, afternoon. No, I'm appearing on behalf 3 of the victims that have been that have lost over $500,000 to Mr. Amaya and his brother.
No, you're not representing the defendant, clearly.
No.
Got it. All righty then. Back to you, Ms. Zeth.
Right, so I don't know if counsel wants to be heard on behalf of the victims. I believe you just stated there's over $500,000 worth of loss. There's also some victims who are present. It's a significant amount of money, and it looks like he used this money to live the high life. He scammed them out of their money, and now they have nothing. State's requesting an increased bond on count 1, maybe $50,000 with a nebia.
You said 550.
Yes.
All righty.
Judge, I would ask for standard bond, which is $15,000 per count.
And what is your argument, if any, in relationship to a nebia requirement?
I would ask that you not require a nebia, Judge, as it would just delay being released.
All righty then. I'm going to set the bond in the amount of $30,000 in this case with a nebia requirement, noting the defense objection. And then I think my work is done.
And you're onto the state.
Now, on the other hand, let me finish up. Mr. Amaya, at some point in time, you may get released from jail. If that is so, you are prohibited from having any contact with Robert Sachs, Julian Acevedo, someone whose initials are MK. You can have no contact with Terrence Keeby or Haiti Keeby. This means you cannot contact these people directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. You must stay at least 500 feet away from any of the alleged victims, their homes, their places of employment, and or where they may go to school. Also, there is to be no electronic contact, no emailing, no text booking, no Facebooking, no Instagramming messages, Twittering. Any type of electronic contract is strictly prohibited as well. Do you understand those conditions, Mr. Amaya?
Yes.
All right, then my work here is done. Thank you. Now I have a case of Emmanuel Amaya. Got it. Take your time, Ms. Curry. And Mr. Cathero, you're still here in the Emmanuel Amaya case as well?
Your Honor.
Yes, Your Honor.
Okay.
Amaya, that's 30,000, 2,500, and 2,500 plus a nebia.
Yes. Emmanuel Amaya, good morning. It looks like you've been charged with a grand theft vehicle. That is a grand theft, a first degree felony punishable by a lot. You're also charged with a third degree felony, organized scheme to defraud, and a third degree felony for a securities fraud. Let me ask you this. Have you made arrangement? Do you have a lawyer at this time?
No, I don't.
Do you own any real estate property?
No, I do not.
Do you own a vehicle or a boat? Are you working?
Yeah, I'm not.
Do you have a bank account with more than $1,000 in it?
No, I do not.
Uh-huh. All right, then for the purposes of this morning's hearing, I'll appoint the public defender to represent you. I'm going to reread the rest affidavit to see if there is probable cause.
There's an issue on the A form. It was booked as grand theft of a vehicle. It should be grand theft first degree.
Yeah, I see the subparagraphs recite the appropriate. I don't believe it was a vehicle, but grand theft in the first degree due to the amount of money that is alleged to have been taken. Hugo Emmanuel. See, Emmanuel. It's isolated for this fellow. Emmanuel. Emmanuel. Probable cause is found. The bond in count 1 is $30,000 and count 2 will be $2,500. Count 3, $2,500, and bond is there is a nebia requirement. Anything else?
Your Honor, what was count 1?
That was 30,000. Now, Mr. Amaya, if and when you will make bail and are out of jail, you are prohibited from having any contact with Julian Acevedo, someone whose initials are M.K., Terrence Keevy, Haiti Keevy, and Robert Sachs. You cannot contact these people directly or indirectly. You cannot contact them in person, in writing, by phone, pager, fax, or through third persons. You must stay at least 500 feet away from the victim, their home, their place of employment, and or their school at all times. There is to be no electronic contact, such as emailing, texting, Facebook, Instagram, Twittering, or any contact whatsoever. And do you understand those to be conditions of your remaining out of jail should you make a bond?
Yes, I just have one thing. I believe works complex. So if I drive by, is that a violation?
I'm sorry, but your sound is cutting out quite a bit.
He's saying that one of the alleged victims works in the complex where he lives.
Uh-huh.
So if he drives by, he wants to know if that's a violation.
He cannot have any contact with that person.
That's fine. Just don't want him to see, oh, I just say, oh, 500 feet. Like, I'm not trying to contact him. I just don't want
So as long as he's not reaching out and trying to make any contact with him, he's still fine living in the complex, Judge. Is that correct?
Your client is to have no contact with any of the enumerated parties in the order.
Okay, thank you.
Thank you.
And the next file I'm calling will be that of Julio Salvador Tierra Torres.
Should qualify for pretrial.
English or Spanish?
English is fine.
Looks like probable cause has been found on the charge of cocaine possession. I'll order pretrial services in your case with an alternate bond of $1,000. A condition of, you're making pretrial services or the alternate bond is that you, cannot be in possession or use any illegal drugs while you're on release. Do you understand that? All right. Thank you. Next file on call day will be that of Lee Herbert Jenkins. Good morning, Mr. Jenkins. Looks like you're currently out on felony bond, and now you picked up a new arrest for allegedly being in possession of crack, making threats to a law enforcement officer, and resisting an officer without offering to do violence. When you were released on bond by the other judge, one of the conditions of that release was that you not get arrested for any new offenses. So I'm going to need to hold you until you talk to the other judge about this new arrest. Thus, there is a no bond hold on 25-17521. On the new charge of possession of narcotics, let's see. My goodness gracious, there is probable cause for possession of some cocaine. How about the rest of this? Allegedly did not allow the deputies to close the door by keeping your feet out and threatened to shoot him at a later date. Okay then. Any argument on probable cause there, Ms. Curry?
Yes, Judge, there's nothing indicating that Mr. Jenkins was in possession of room blood.
Let's see, back it up. Let's see. Spoke to complainants, defendant Jenkins.
Also, when you have anonymous people and there's no one home, there's no witnessing of Mr. Jenkins having possession of any bandage.
Let's see.
So it was a very specific tip, and what the officers found was consistent with that tip.
Reading it for the third time now. Interesting. Ms. Seth, I'm not sure they can.
So Judge, the anonymous complaints said that the person who was selling was wearing a yellow shirt. The defendant's the only one with the yellow shirt on the scene. One of the complainants said that the drugs are hidden inside of the luggage bag on the top zipper inside the shopping cart. And that's where the drugs were found.
Any other access you need to the record there, Ms. Curry?
Judge, without having a name of a person and seeing Mr. Jenkins having possession of anything, just claiming and not providing their name, there's no reasonable basis, Judge, to believe what they were saying.
Okay. Any further access to the record there, Ms. Curry?
Okay.
No, Judge.
All right, so there is a no bond hold in 25-17521. Probable causes found on all three counts. Let's see, the bond in count 1 will be 1,000, count 2 is 1,000, and count 3 is 500. Now we'll get you sent over to see Judge Leticia on Monday, and you can talk with her about the no bond hold. All right then. Let's see, the next case we have will be that of William King. Morning, Mr. King. I'm looking at the arrest affidavit from yesterday. You're charged with grand theft of a firearm, possession of cocaine with the intent to sell it near a public housing, attempt to sell cocaine, sale, manufacture, possession, delivery of marijuana, possession of cocaine with a firearm, introduction of a controlled substance into the jail, and possession of marijuana with the intent to sell it while armed. Give me a second to read this affidavit and see if there's probable cause or not. Then we'll be right back with you. Let's see, a search warrant was executed. SWAT officers located a fire on Mr. King. And then what? All right, then, Ms. Curry, do you have any argument on probable cause on this A form?
Yes, Judge. The arrest form does not indicate Mr. King was ever in possession of a firearm.
Was not in possession of what?
A firearm?
Well, how about the one they took off him when they first approached him?
I don't see.
Page 1, second paragraph.
Oh, I missed that.
Yeah, I did the first time through as well.
With regard to count 1, Judge, he's charged with grand theft of the firearm. I don't see.
Aha.
Maybe I missed it because there's a lot in the A form, but I don't see that.
Got it.
Reported stolen at all.
What else?
It seems to be. Count 2 and 3. Count 3 is incorporated in count 2. There's nothing indicating any basis for count.
Any basis for what?
For count 6, the introduction into the jail.
So it says that he was transported to TGK and they searched him and they found drugs.
Right. It just sounds like they didn't search him when he came in, not that he had intent to bring anything into the jail. So that just sounds like bad police work. And count 4 is subsumed in count 7.
Oh. Ms. F, on the theft of the firearm charge, would you agree or disagree that doesn't appear to be any statement about which of the firearms was stolen?
Agree.
All right, so count 1 will have to be a release outright. Let's not get excited yet. Let's see. Count 2 is the cocaine sale, possession, or delivery within public housing unit. What would the state's recommendation on the bond be?
So for all of the counts related to cocaine, state's requesting a total bond of 15,000. So if your honor would split 15,000 between counts 2, 3, 5. So maybe 5,000 each on 2, 3, and 5.
And would you agree then that counts four? Well, let's see. Count
four is-
one should be released outright. Count two should be 15,000. Count.
Judge,
I'm sorry.
I'm asking for 15,000 split between 3 counts.
Amongst 3 counts.
Right. So
And you're
5,000.
asking that those be split amongst 2, 3, and 5?
Yes.
All right.
That's fine.
Count 2, 3, and 5. The bond is $5,000. Now we must make findings on counts 4, 6, and 7.
4 requesting 2,500 cannabis.
6 is the we took the marijuana into jail with us.
I think it was cocaine. Miss Corey, are you okay with $1? I don't know if he was searched first.
$1 fine.
All right, and down to count 7.
Count 7, we could do $1 as well.
All right, so let's review to make sure corrections and I wrote things down correctly. Count 1 is a release outright. Count 2 is 5,000, 3,000. Count 3, 5,000. Count 4, 2,500. Count 5, 5,000. Count 6 and 7 are $1. With that, then your bonds are set. Let me write this down so it's halfway legible. And now I'm to call the file of Jack Voltaire.
Your Honor, we should be on Jones.
All right, I was told corrections wanted me to call Jack Voltaire, but I won't. I'll put it back aside. Never mind.
I apologize, Your Honor. Yes, you're right.
So let's see. Now I have a file of Zachariah Jones. Good morning, Mr. Jones.
No, Judge, I'm sorry. We got Mr. Voltaire, right? Jack Voltaire?
Yeah, like the
This is Jack Voltaire, Judge. He's on page 15. I think he was the file that you just pulled out of me. That's whose corrections asking to take out of time. Just
Hello, Your Honor. I know. I apologize.
Good morning, sir. Let's see. Are you Jack Voltaire?
Sometimes I happen to be today.
Well, are you Jack Voltaire this morning?
As we speak, yes, Your Honor.
Well, all righty then. I'm calling this case. You're charged with allegedly committing an act of criminal mischief back on October 26th. And let's see, any argument on probable cause there, Ms. Curry?
No, Judge.
All right, probable cause is found. This is a charge where you allegedly tore a banner off someplace called over
the Gardens,
1155 Northeast 126th Street. And as we go forward and handle this case, I'm going to order that you cannot go to the Gardens at 1150 Northeast 26th Street anymore. You must stay away from there. Do you understand that, Jack?
Your Honor, can you repeat the location one time?
1150 Northeast 126th Street. Okay.
Not familiar with the location, but I understand, Your Honor.
And now let me set a bond. The standard on this case is usually 2,500. Care to be with Mr. Curry?
No, Judge.
Right, then the bond is set at 2,500. Next, I'm going to try and call Zachary Xavier Jones. Good morning, sir. It looks like you're charged with grand theft of a firearm, carrying a concealed firearm, possession of a weapon while committing an offense, and allegedly fleeing and eluding a law enforcement officer. Give us a moment to see if there's probable cause. Any argument on probable cause, Ms. Curry?
No, Judge, not on probable cause.
All right, probable cause is found. Now let's talk about setting some bonds.
I would ask if you would consider a program for Mr. Jones. He currently cannot afford a bond, Judge.
What kind of a program would you use for this case?
I would ask if you would consider either pretrial services or house arrest. I had seen no prior adjudications, no withholds.
So there's some juvenile history out of Michigan. Don't know how long he's been in South Florida. I see he's only 18. I'm okay if Your Honor would do house arrest level 2, letting him only go to school and work. Did he graduate, Ms. Corey?
He's still in school.
High school?
Yes, ma'am.
All right, then. Let's see, house arrest, level 2, alternate bond in count 1 will be 2,500, count 2, 2,500, count 3, 2,500, count 4, 2,500, and count 5, 500 as alternate bonds. You're being placed by the court on house arrest. They will interview you and try and fit you out with a house arrest bracelet. You must follow all directions of the programs or your bond can be revoked and you will be returned to jail until we try your case, which could take a year. Thanks for coming. Jorge Luis Battle. Now to corrections. Did you want me to call Rodolfo Diaz out of turn or not?
Your Honor, yes.
No? Okay, I have standing in front of me Battle, and then I'll flip to Diaz if you want. Mr. Battle, English or Spanish?
Either's fine.
Espanol. Okay, so
You said either one is fine.
Either's fine. English.
you're charged with possession of cocaine with firearm and conspiracy. Wait a minute. Cocaine possession conspiracy? Let me read this. What?
So Judge, we can ROR count 2. I see no criminal history. He should qualify for a program, but I also see that he has a bondsman who is present.
All right. That would be a ROR on count 2 and on count 1. Possession of cocaine with a firearm. I will.
Would you do 2,500?
Set bond at $2,500.
Thank you.
And corrections, Rodolfo Diaz. Rodolfo Diaz.
We'll need the Spanish interpreter, please.
And we have one with us. You are charged with 2 different arrests.
Señor, usted enfrenta 2 cargos diferentes.
One was possession of cocaine and possession of drug paraphernalia on November 6th.
Uno fue el 6 de noviembre por tenencia de cocaína y de parafernalia para drogas.
That was for allegedly smoking the crack out in public on 21st Street.
Eso fue por presuntamente fumar consumir la droga en público. Eso fue el 21 de noviembre.
And then you're charged with introducing or taking drugs into the jail on November 6th and possession of more cocaine.
Y la otra fue del 6 de noviembre por introducir drogas a la cárcel y por más tenencia de drogas.
Hearing no argument.
Judge, I do. On the case F25-24266, you can't fail to do your police work and decide you want to do your
$1 as an alternate is fine as to that case.
$1 on
Entonces, le aprueban $1 de fianza y como alternativa, I'm sorry, $1 and as an alternate.
All right, I think he probably qualifies for a program. So as to that case, we could do $1 on each count as an alternate.
Como alternativa, él calificaría para algún programa y como alternativa le pueden aprobar $1 de fianza para cada uno de los cargos.
So, I'm Miss Curry, as you were speaking, Miss F joined in, and so I couldn't understand what either of you are saying. But
Right. So Judge, Ms. Corey's saying he shouldn't be charged with introduction because like if the police properly searched him, they would have found it earlier. And I don't know whether or not they gave him the opportunity to disclose the drugs.
Entonces la fiscal no sabe si de pronto de hecho le dieron la oportunidad de revelar que tenía esas drogas.
What I think I heard at the end was each of you agreed that the counts 1 in 2 in 24,266 should be $1. Is that what I heard?
1 through 4.
Entonces para el cargo del 1 al 4 se le puede aprobar fianza de $1.
Yes, and we're asking for pretrial services with an alternate bond of $1 each count in 24266.
Entonces lo que la defensa está pidiendo es el servicio previo al juicio y como alternativa una fianza de $1.
So, probable cause is found also in 24,231, and I will order pre-trial services with an alternate bond of $1,000 in each count. I'm sorry, $1,000 in count 1 and $500 in count 2.
Entonces, para el caso 24 que termina en 231, le ofrecen el servicio previo al juicio como alternativa $1,000 para el primero y 500 para el segundo.
All right, then. Next, we have the file of Devontae Willens. Ooh. Looking for Devontae Willens.
Your Honor, for Mr. Williams, they gave him a $5,000 on his traffic case, and then he's also being held on a probation violation no bond.
I see that. Thank you. And that would be in 21-21698.
Correct.
Hopefully, Mr. Willens will find time in his busy schedule to join us. Good morning, sir.
What about?
So it looks like you're being held with no bond on your probation case, and you need to see good Judge Loading Gene. I found probable cause in the last 2 charges I have in front of me. So in the fleeing and eluding count 1, the bond is $2,500, and resisting the bond in count 2 is $500. We'll get you in front of Judge Gene in the next day or 2, and you all can talk about your probation hold. Next up, we have the file of Rolando Aguiar. English or Spanish?
He speaks both. Are you on Spanish? Spanish is preferred.
You're charged with grand theft in the 3rd degree. Represent counterfeit license equipment.
Enfrenta hurto mayor en el 3er grado y también por equipo para falsificar licencias.
Huh.
There's
Interesting. Anybody care to be heard on this?
Yes, Judge, on count 2, he's charged under the wrong subsection of the statute. He's charged with possession of the equipment. Counterfeiting, the allegations are he was in possession of one counterfeit Florida driver's license. So it should be felony.
State?
La defensa dice que no hay realmente motivo fundado, que el segundo cargo no quedó correctamente escrito en el informe del arresto.
I agree, Judge. Requesting 2,500 each count. The defendant does have a prior federal conviction for identity theft.
La fiscal está de acuerdo con 2.500 por cada uno de los cargos. Este acusado ya tiene, de hecho, antecedentes penales a nivel federal por el mismo tipo de fraude de documentos de identidad.
Bonding count 1 and count 2 is $2,500.
Entonces, 2.500 tanto para el cargo primero como para el segundo.
Court has ordered you to stay away from all mailboxes except your own.
Este despacho le ordena a usted que se mantenga alejado de todos los buzones de correo, excepto la suya.
Next, we have the file of Christopher Cockcroft. Let's see, Mr. Cockcroft, it looks like there's, you've been picked up on a arrest warrant for the charge of sexual battery. I see Judge Jean set a bond of $100,000 with house arrest. Anyway, anybody care to be heard on that?
Judge, I would ask for standard bond, which is $7,500.
Right, and the state's requesting.
I don't feel comfortable changing Judge Jean's bond in this case, but perhaps you all can set it in front of the trial judge. So this is going to be a bond of $100,000 with house arrest.
Your Honor, you said
level 1. Yes. Yes. So it's $100,000 plus house arrest at level 1. And we'll set it in front of the trial judge and see if he or she chooses to change this. Now, Mr. Cockcroft, if you were to make your bond, you're prohibited from having any contact with an individual whose initials are DAL. This means directly or indirectly, in person, in writing, in person and writing by telephone, pager, fax, to third parties. You must stay at least 500 feet away from that person at all times, their home, their place of appointment, school, anywhere else they might be seen. And you cannot have any contact, emailing, texting, Facebook, Instagram, messaging, or twitting. There's to be absolutely no contact, and that's been ordered by the court. Next, I'm calling the file of Andrew Rodriguez Gonzalez. Interesting. That doesn't look like Andrew Rodriguez. So let me see if I can figure out who this is. Are you Mr.
The last defendant. We're waiting for Mr. Rodriguez Gonzalez to step in.
You're Mr. Rodriguez?
Yes.
He's
we flip back to
Spanish is preferred.
English or Spanish?
Spanish, please.
Spanish. All right, you're charged with an organized scheme to defraud.
Señores, usted enfrenta el cargo de esquema para defraudar organizado.
Grand theft,
Hurto mayor,
retail fuel theft or tampering with a fuel dispenser,
sabotaje, perdón, de un dispensador de combustible,
fuel unlawfully obtained,
combustible obtenido de manera ilícita,
retail fuel theft, modifying a vehicle fuel tank,
modificación ilícita de un tanque de gasolina
and criminal mischief.
y daño a propiedad fechoría.
Any argument on probable cause?
La juez quiere saber algún argumento para motivo fundado.
No, I do not.
No hay argumento.
Let's see, looking for the face sheet on this one. As we go forward, Mr. Rodriguez Gonzalez, there is a stay away order in your case.
Señor, en su caso hay una orden de alejamiento.
You are ordered to stay away from the 7-Eleven, all 7-Eleven stations in Miami-Dade County.
Se le ordena que se mantenga alejado de todas las estaciones 7-Eleven de gasolina del condado de Miami-Dade.
Yeah, figure out how to set some appropriate bond in these charges.
Vamos a ver qué podemos fijar como fianza que sea adecuada.
The defendant does have, I see, prior arrests out of county.
Creo que este acusado tiene arrestos en el pasado de otro condado.
State's request would be 5,000 on count 1 through 5 and 150 on count 6.
Este fue interpreted 1 through 5. What is it again, please?
Requesting 5,000.
Got it. On each, right?
Yeah.
Got it, thank you. Entonces, la fiscalía está pidiendo para los cargos 1 al 5, $5,000 de fianza para cada uno de los cargos y 150 para el número 6.
Ms. Curry, care to be heard?
I would ask for standard bond, Judge. 20 third degree felonies.
La defensa está pidiendo la fianza estándar de 2,500 para esos delitos en tercer grado.
Do you know prior history for him?
No veo antecedentes penales aquí.
Minor.
Count 1 through 5, the bond is $2,500, and count 6, the bond is $150 with a stay away order from all 7-Eleven.
Entonces, para los cargos 1 al 5, la fianza serán 2,500, para el 6, 150 y una orden de alejamiento de todos los 7-Elevens del condado.
Next up, we have Charles Nathaniel Webb. EWLS, third or subsequent. On the mobile. Mr. Webb, you're charged with driving with the license suspended or revoked, and this is allegedly the third or more time in this case. Probable cause is found. Standard bond is usually $2,500. Corey, can be heard?
Yes, Judge. With regard to the arrest form, it only says that he has prior suspensions. It does not indicate conviction on the suspensions. So it looks like it's just a driving while license suspended charge. I would ask for pretrial services with an alternate bond of $250.
F?
Give me 1 second, Judge. Let me see if I can find the convictions.
All right,
Here we
pretrial
go.
services.
Judge, 1 second, I can find it. It's right here.
Pretrial services, alternate bond is $2,500 with a no drive court order.
Great.
Next, we have the file for James Millen.
Your Honor, for Mr. Webb, that's a straight bond of 2,500.
Pretrial services, alternate bond is $2,500. Let's see. F has started screen sharing.
So right, it's my computer's acting a little wonky.
Hey, I don't know what that means, but if I did, I'll do it. Anyway, while someone who is more electronically savvy, figures out what's going on with the screens, I'm going to turn and call the file of James Mullen. Good morning, Mr. Mullen. It looks like you have been arrested for aggravated assault with a deadly weapon and domestic violence battery on November 5th. And then I have a second arrest form claiming that on about September 29th, you committed an armed robbery with a firearm. Let's start with that one. It's more interesting. Let's see. Couple people, ski masks, gloves, get out, handgun, demanded his bracelet, physical altercation. Ooh, ouch, that sounds like it hurts. Any on probable cause on the armed robbery charge there, Miss Curry?
No, Judge.
Probable cause is found, and in case number 2524242, there is no bond. Now, let's look at the other case from October 6th. Aggravated assault with the deadly weapon. Let's see what's going on with that one. Struck her multiple times in the face. Any argument of probable cause on that charge, Ms. Curry?
No, Judge.
All right, probable cause is found. Count 1, the bond is $5,000, and count 2, the bond is $100. Should you ever be released from custody, sir, you're ordered not to engage in any criminal activity. You cannot use or possess illegal drugs. You cannot use, possess, purchase, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, or concealed weapons permit to the nearest police department and file a receipt with the court. You are prohibited from having any contact, direct or indirect, with Ginny Aguirno or Aganor. This means in person, in writing, by telephone, through social media, or any other electronic means. You must stay at least 500 feet away from the victim at all times. Do you understand these conditions of your release, Mr. Miller? All right, then. So, make sure I made the notes on the file, and then I will move to the next case. Good morning, sir. Are you Frank Cruz? Okay, it looks like you were out on bond and got arrested for a new charge for allegedly being in possession of crack cocaine and drug paraphernalia. So I'm gonna have a no bond hold on you until Monday morning at least, where you're going to need to go talk to Judge Altfield about your getting arrested while you're out on bond on felony 25731. On the new charges, you've been arrested for possession of cocaine and possession of drug paraphernalia. Let's see what we have here. Glass with residue cocaine in it. Any argument on probable cause, Ms. Curry?
No, no.
All right, probable cause is found. I'll be glad to get bonding count 1 in the amount of $1,000 and count 2, the bond is $500. Next up, I have a file for. Oh, and Mr. Cruz, I need to order that you stay away from the address of 1742 Southwest 8th Street. I have a file for Christopher Christie.
Judge, there's 2 cases for Mr. Cruz.
Well, apparently,
stay away order was for the one that you didn't call yet.
Sorry. Thank you for that reminder. Also, Mr. Cruz had the burglary of a occupied structure case for which there was probable cause and a stay away order. And let me set the appropriate bonds eventually. And the burglary of an occupied structure bond should be $2,500, and petty theft is $150. Thank you for the reminder to make the notations on both files. And if there, let's call the file now Christopher Christie. Let's see, you're charged with allegedly being in possession of cocaine within 1,000 feet of a protected area, as well as grand theft vehicle. You allegedly stole the car from your aunt or your aunt, and then let's see, I see the possession of cocaine. I'm not
It's just simple
within
possession.
a protected area, so state
Simple possession.
all right, so I'm gonna find simple possession, grand theft vehicle.
Should be a 3rd-degree felony.
Which is,
And I think the defendant may qualify for pretrial.
oh, thank you, Eric. Curry, care to be heard? No. Pretrial services, alternate bond, count 1 is $2,500. Count 2, alternate bond will be $1,000. I'm now going to call the file for Neville Moore.
Your Honor, Mr. Moore is also being held on a probation violation.
In case 18-12440. Mr. Moore, you're being charged with an organized scheme to defraud, and there is a probation violation warrant that is holding you up for no bond. Let's see the organized scheme. Judge Brinkley signed a search warrant. Let's see what we have going on here. Interesting. Haven't seen one of those today. Anyway, there is a no bond hold on 18-12440, and standard bond in this charge should be $2,500. All right then.
Is that with the Nevia?
With a Nevia.
Judge, I would ask you for no Nevia for $2,500 bond, please.
Hey.
The judge yesterday was setting $15,000 with Nevia on the co-defendants.
I set this for $2,500 with a Nevia. There is a no bond hold for the probation case, and now I'm calling the file Arif Spencer. Trying to finish the morning calendar before midnight. Looking for Arif Spencer? Let's see, you're charged with allegedly committing aggravated assault with a firearm. Pulls out a firearm. Points him while yelling. Any argument on probable cause?
No, Judge.
Probable cause is found. I'll be glad to set bond in the amount of $5,000. Thank you. I'm also ordering, should you be released from jail, that you have no contact with the alleged victim in this case, whose initials are ERP. This means you cannot directly or indirectly contact this person by phone, pager, fax, or through third parties. You must stay at least 500 feet away from that person, their home, their place of employment, and no electronic contract of any means whatsoever. And these will apply to your release. With that, then, I'm switching to the file of Jerome Smith. Mr. Smith, you have arrest affidavits from July 17th of 2025 for false information with the pawnbroker and dealing in stolen property. Any argument on that one, Ms. Curry?
On the pawnbroker one moment.
Any argument on the pawnbroking stolen property arrest affidavit, Ms. Curry?
No.
All right, probable cause was found on counts 1 and 2 of that charge. And then you also on the next day are charged with allegedly going into Walmart and committing an act of retail theft. Any argument on that one, Ms. Curry? All right, probable cause is found. Now let's set some bonds. In the meantime, I need to tell you, Mr. Smith, you ordered not to go anywhere near Walmart at 15601 Southwest 127th Avenue, and you're ordered to stay away from that address. Stay away order. And let's set a bond on the stealing from Walmart charge. Let's see. That will be $2,500. And the false pawnbroker information. Let's see. That should be $2,500. And dealing in stolen property, $1,000. And your bonds are set. All right then, thanks for coming. Next file on call will be the file of Bayardo Obaño Leyva.
Spanish, please.
You're charged with being in possession of cocaine.
Viendo el cargo de tenencia de cocaína
Within 1,000 feet of a convenience store.
dentro de 1000 pies de una tienda.
And possession of drug paraphernalia.
Y también por tenencia de parafernalia para drogas.
Any argument on probable cause, Curry?
Oh, yes, Judge, I do.
La defensa tiene argumento para motivo fundado.
There's no enhancement for a possession within 1,000 feet, Judge. It doesn't apply for simple possession.
I agree.
Tanto la defensa como la fiscalía están diciendo que el informe no amerita que se impute ese tipo de cargo.
So if this would be a possession of cocaine, which is a third-degree felony for count 1 and count 2, they charged it as a felony transportation.
It's possession of drug paraphernalia. Bonding count 1 is $1,000. Bonding count 2 is $500.
Which
entonces se reducen los cargos. Para el primer cargo son $1,000 de fianza. Para el segundo 500. Go ahead, counsel.
Jose Garcia,
would you consider tap for Mr. Obando Leyva? He's currently homeless. I see no history for him.
La defensa le está pidiendo a la fiscal, a la juez, si le puede permitir el programa TAP por ser indigente y no ve antecedentes.
I'm sorry, what?
I see no prior history for Mr. Obando. I'm asking as an alternate to the $1,500 bond that you grant TAP.
Oh, okay. You asked for TAP. F?
Can we just see how long he's been in Miami? If it's over a year, that's fine.
Entonces la fiscal pregunta hace cuánto tiempo que está en Miami. Si hace más de un año, está bien.
CAP alternative program bond in count 1 is 1,000 and bond 2 and count 2 is 500 as an alternate bond.
Right, but Ms. Corey, he's been in Miami over a year?
Aquí vas. ¿Un año más?
Yo tengo
2 años.
Sí.
About 2 years.
Okay, perfect.
Jose Carlos Garcia Clavera.
We'll need a future court date for Mr. Obando.
La defensa acaba de pedir una la fecha de cuando el señor Obando tiene que regresar.
You want to do December 8th? Is that okay with the clerk?
That is what I said, December 8th.
And
Entonces, para el 8 de diciembre.
Altfield. 6-2. Got it. Thank you.
Tiene que volver a la sala 6-2 con el juez Outfield de esa fecha de diciembre.
English or Spanish?
Spanish, please.
You're charged on October 8th with robbery.
Se le imputan cargos de robo el 8 de octubre.
And domestic violation of a domestic injunction. Stay
Y
away.
quebrantamiento de un interdicto de una orden de alejamiento.
Probable found.
Si haya motivo fundado.
Should you be released from jail, there are some conditions that will apply to your staying out of jail.
Hay unas condiciones cuando es excarcelado, hay unas condiciones que tiene que cumplir.
You cannot engage in any criminal activity.
No puede participar de ninguna actividad delictiva.
You cannot use or possess any illegal drugs.
No puede estar en tenencia ni consumir ningún tipo de droga ilícita.
You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco puede estar en tenencia, portar, ni usar ningún tipo de armas de fuego ni municiones.
You must immediately surrender any firearms or ammunition to the nearest police department and file a receipt with the court.
Cualquier armas de fuego o salvoconducto para portar armas tiene que entregarlo en la estación de policía más cercana. El recibo que le den allá tendrá que radicarlo ante la corte.
You are prohibited from having any direct or indirect contact with Yanali Torres.
No podrá tener ningún tipo de contacto directo ni indirecto con Ilani Torres,
including contact in person, in writing, by telephone, or through social media.
Eso incluye contacto por terceros a través de las redes sociales, por teléfono o en persona.
You cannot contact her through third persons, and you must stay at least 500 feet away from her at all times.
No puedo utilizar a nadie para mandarle razones a esa persona y en todo momento tendrá que mantenerse alejado a 500 pies de esa persona.
You understand the conditions of this pretrial release order?
¿Entiende usted las condiciones de esta orden de excarcelamiento previa al juicio?
Sí.
Yes.
In the robbery by sudden snatching count 1, state would like what bond?
Ahora, para el robo por raponazo repentino que pide la fiscalía para fianza.
2,500.
2,500.
The violation of an injunction?
Y por el quebrantamiento del interdicto.
That one's a little tricky because I'm not sure if it's based upon the stay away. Oh, okay. No, that's fine. $1,000.
$1,000 está bien.
Curry, what's your request?
Judge, the case for that stay away order was actually no action. Would you consider an ROR too?
Pedimos que le den libertad bajo palabra que no sea judicializado el segundo cargo.
It was valid.
Bonding count 1 is $2,500. Bonding count 2 is $1. Thanks for coming.
Entonces, $2,000 para el primero, para el segundo, $1 de fianza. Muchas gracias.
Daniel Sepulveda Porras.
He has a hold for immigration.
Oh, well, Ollie. Good morning. You're charged with being in possession of a controlled substance and possession of a fictitious driver's license.
Spanish.
Yeah, what are the charges again, please?
You're charged with being in possession of a controlled substance as well as a fictitious driver's license.
Enfrenta el cargo de tenencia de una sustancia regulada y también de tenencia de una licencia falsa.
The bond in probable cause is found. The bond in counts 1 and 2 is $2,500.
Entonces, si haya motivo fundado, la fianza para el cargo 1 y 2 son $2,500.
And there is an immigration hold that has been placed against you. So even if you should make your bond, you will not be released from custody.
Ahora también tiene una orden de retención migratoria, lo que significa que aún así pueda pagar fianza, no podrá ser puesto en libertad.
Calling the file Jacques Andre Turner.
Your Honor, Mr. Turner refused court.
Refused again? Again? All righty. That is disappointing. Probable cause is found. Ms. Kerr, would you like me to set the bonds or off with his head? Your choice.
Your Honor, you did say Turner, correct?
Yes, I called Jacques Andre Turner.
Judge, we'll go ahead and waive his presence at this time.
And set a bond?
Yes.
All right, bonding count 1 is $2,500. Bonding count 2 is $500 with a stay away order to be delivered to him in his current abode. Thank you for coming.
Judge, there's no age for count 1. Would you do a $1,000 bond for count 1?
No, thank you. Now I'm calling it Sebastian Ballatino.
Earlier, if you'd like to take them now.
Your Honor, what was the bond?
Let's see.
25?
Returning to Turner is $2,500 and $500.
Judge, would you like to do the ones that we already passed that were over in jail arraignments, or you want to just keep going? Whatever you like.
I'm hearing microphone job pastor like.
So with our sound system, Judge, we have Mr. Triana and Mr.
Okay.
If you'd like to take those out of turn.
I would.
Perfect. We'll take Mr. Triana then, if that sounds good to you.
Oh, yes. It's
One.
announced, please. I have Stephen Triana's file right here.
Yes, Your Honor.
Good afternoon, sir. It looks like you're charged with, let's see, motor vehicle registration, license plate sticker counterfeiting, driving with license suspended with financial responsibilities, but that's not my problem. So I have just the kind of like forged or motor vehicle sticker thingamajobber.
Your Honor, he received pretrial alternate 650 on his
So
misdemeanor.
probable cause is found. How about pretrial services with an alternate bond of $1,000? Would that work out for everybody?
Yes. Thank you.
Yes.
All right, then. We'll do that. Pretrial services, alternate bond of $1,000. It might be in your best interest not to be driving a car for a while now. Okay? Is there someone else you'd like to have me call? Because maybe they'll join us now.
Be Mr. Fuller on page 6. Mr. Fuller, present.
I have a file for Mr. Fuller. Okay, it looks like you picked up a charge for stealing. What level of felony is this? Second degree felony, because it was apparently a higher amount of money.
It was over $20,000.
$20,000. Anybody care to be heard?
The defendants got an arrest out of Orlando, also for grand theft. That was back from February. Based upon the amount of the theft, the state is requesting a bond. Also, the defendant came in on bench warrants.
Also what?
He came in on bench warrants.
Ooh, not bench warrants. Like didn't show up in court on a prior occasion?
Yes.
Okay. Ms. Curry, care to be heard?
Judge, I'd ask for $2,500 bond for this case.
If and when you make any bond and get out of jail, Fuller, you are ordered not to go to Allo at 7535 Southwest 88th Street, and you understand there is a stay away order from that establishment.
Yes.
All right, well, your bond in this case is going to be $3,000 and stay away from that store. Now, let's call the file of Sebastian Valentino.
Your Honor, he's in NBC.
Do you want me to set it for this afternoon
Yeah.
or tomorrow? All right, set for afternoon. I have no clue, but it's a Sebastian Valentino. I'll just put it to the side here. And now,
Where was Mr. Valentino?
he wasn't here this afternoon.
NBC.
We're gonna try this afternoon.
Thank you.
We might still be in court when he shows up. Anyway, let me call Cesar Morales Gamedo.
Let's hope not.
Gamaneda, I'm sorry.
Spanish, please.
Spanish? All right, you were charged with stealing from Home Depot.
Señor, se le acusa de robar del Home Depot.
Looks like they claim you had more than $1,000 worth of merchandise stuffed down your pants.
Ellos dicen que parece que tenía más de $1,000 mercancía escondida en sus pantalones, evaluada en más de $1,000.
Well, let's see. Looks like
he was charged under the riot statute. There's no riot. It's a third-degree felony, Judge.
Charged under the what?
Riot during a riot.
Whoa.
Enhanced for a riot, but I don't hear any riot.
Well, it just looks like a grand theft case to me, not a riot one.
Bueno, parece que fue bajo un disturbio, no parece que fue, de hecho, para mí parece un delito mayor.
I mean, you can't really call a party in your pants a riot. Anyway, state agreed that it should be grand theft, and what do you suggest the bond should be?
I agree. Requesting a $2,500 bond. I believe the defendant's on probation in Broward also for theft.
Oh my.
Entonces, la fianza 2,500, la fiscal está de acuerdo. Y dice la fiscal, creo que también tiene una fianza del condado Broward por hurto también.
As we go forward, Mr. Morales, I'm ordering you to stay away from the Home Depot at 1650 Northwest 117th Place.
Señor, le ordeno que se mantenga alejado de Home Depot, que queda en la 1650 del 117 Place.
And your bond is $2,500.
Su fianza serán $2,500.
Next, I have the file for Pedro Cabrera.
He refused, Your Honor.
Oh, golly.
Maybe
And
Ms. Coyle
on
waived-
probation. Oh, my goodness gracious. Curry reset. What? She's busy. Wait a sec.
Ms. Coyle, you want to waive Cabrera? He refused, but he's on probation.
Yes.
Rebecca, would you like us to set him for this afternoon or tomorrow?
We'll waive his presence, Judge.
Probable cause is found. Now reset to tomorrow. Want me to set
Yeah.
up a bond? He's on probation, you know.
Set a bond.
All right. We'll set a bond in the amount of $1,000 on count 1 and $500 on count 2, noting that there are probation holds in 24-11022 and 24-23050. Be right with you. And good afternoon, sir. Are you Ian Wallen?
Yes, Judge.
Okay, it looks like you got picked up for possession of cocaine and possession of drug paraphernalia. Let's see, baggie in his hand. Ooh,
No.
No, that's
that's the other fellow.
Pereira. Mr. Walden's the next paragraph.
See, scale, cocaine residue in our back pocket. One baggie in the right sock. I get things stuck in the laundry all the time in my socks. Anyway, looks like there's a probable cause for cocaine in our sock. Now what should we do?
I would ask for pretrial services, Judge.
F, how do you feel about pretrial services with an alternate bond of $1,000 and $500?
I feel good about it.
Pretrial services, alternate bond, count one, $1,000, count two, $500. And now we have a file for Stephen Alvarez.
He's being held on 2 AC, no bond.
Oh, golly, that must be Mr. Alvarez, English or Spanish?
English.
It looks like you were out on bond in 2 cases, so there's going to be a no bond hold on 2 cases until you go talk to the judge that set that bond and see how they feel about you getting arrested again. So that would be 18665 and 18570, no bond. But let's see the new charges. Regretfully, you've been arrested for possession of a controlled substance, possession of heroin, so cocaine, heroin, something about property lost or abandoned, failure to report, and credit card dealing for other people. So let me read this more carefully.
Can we do everything $1,000? Who's got the ACs?
That's fine.
So, possession of somebody else's stuff you found but didn't tell them about it. Okay. So golly, counts 1, 2, 3, and 4. The bond will be $2,500.
I think I agree to $1,000 on everything, if that's okay with your honor.
Can't hear you.
$1,000 each count, if that's okay with you, Judge.
Bond in count 5 is $500. And I still can't hear you on counts 1, etc.
I was going to agree to $1,000 on every count.
Count 1, 2, 3, and 4. The bond will be $1,000. Got it. And now we have a file for James McCain.
Your Honor, these are added charges and he refused court.
Refused?
Court, what do you want to do? He's got a bunch of cases.
Well, phooey.
We can waive his presence.
All right. Petty theft, probable causes found. Defendant refused. Debt bond. And then the amount of, what do you say, $1,000?
Okay.
And the next file we have will be that of Raymond Arluce. Oh my.
Your Honor, they're in circuit court.
So I think we have to reset it. You don't have the jail card, right?
Yeah, they're in Judge Susan.
PM reset?
Yes.
Okay. Reset this afternoon. This will be our on a second-degree murder charge.
And point, you have not appointed our office for Mr. Arluce, correct? Because he does have a private attorney on his other very serious charge. I did leave a message, but I have not heard back. It might be
okay
now. So I would ask that you not appoint us.
And I shall not.
Perfect. Thank you.
No sense in upgrading his defense this early in the process.
Well, thank you.
Let me call the file of Jackery Hardaway.
He's in Judge Susan's courtroom.
Reset afternoon.
Reset for time.
And same thing with Mr. Hardaway. He has a private attorney on his other very serious matter.
Public defender is not appointed.
Okay.
Now I file for Elijah Torra Alba.
Your Honor, these are added charges and he refused court.
We can wait for his presence.
All right, PC found, bond is $1,000. We have a file for Ricardo Johnson.
Your Honor, after added charges, he refused court.
PC found, bond is $1,000. And Eduardo Iglesias.
Added charges, refused court.
We will wait. Fred.
Probable cause is found, bond is $1,000. Alex Antonio Bryant.
Charges, refused court.
Added charge. Probable cause found, bond is $1,000. Yuri Salgado Martinez.
Added charges, refused court. Oh, these are not added charges, Your Honor. He has a hold for immigration. And he received 2,500 on his misdemeanor case. I mean, on his other felony case. These
And
are
he
added.
refused?
Yes, he refused. Oh, wait.
Defendant refused. Probable cause is found. And bond is $1,000. And we have a file for Yusser Echemedia Rodriguez.
Added charges, refused.
We'll waive his presence.
Probable cause is found. The bond is $1,000. Well, right. I have a file over here of a Sebastian Valentino. I think that's on our PM reset. Is there anything from the morning calendar that we have missed? All right, the time now 12:50. To corrections, what time would you like to return for the afternoon calendar?
As soon as possible.
Can we do
I'll
2?
see you all at 1:30 then.
Okay.
Right. Good afternoon, y'all. Good afternoon.
So let's it's now
Recording
5-1. Let's shoot for Eric. We'll shoot for 2 p.m. 2:30. 2:15. So was that a room?
Wait, Judge, we went from 1:30 to 2:15?
I'm hoping I hadn't turned as slow as molasses on y'all.
I think you just said 2:15, but I'm also confused because I thought it has that's at 1:30. So I'm not sure.
I'll be here at 2:15. If we're ready to go, fine. If we're not ready to 2:30, fine. I'll get too old to yell at you folks for things that you can't control. And I'm gonna go eat my peanut butter and jelly. See you later. Thank you so much for your help. You're welcome.
Upstairs, because that's where they keep all the jail cards for all the different jails upstairs. So they're going to give it back to them when they're done. So they review what they wrote.
Generally, the the most accurate will be the gel.
Okay, now. I know, right? Last part.
Okay, do me a favor, do me. Oh, I haven't even the calendar. Dear God.
Oh, please. Hopefully it's.
Somebody we're probably gonna need this. Oh, we're gonna need it. Okay. I have a feeling it's a problem. They're being real stupid, baby, trying to give a calendar to do anything for me yesterday. I said something. Are you serious? What the fuck are you trying to get people to put it on you? Are you trying to get people to are you trying to get all the new people? Like, no, I'm gonna go back to where I was. Is that what you're really trying to do? They can't learn what they're supposed to learn because you're trying to teach them everything at once, and no brain can absorb 17 subjects at one time. Oh, she used to be around here either. Well, our complaint is not the work. The way to play. But it's the truth though. It's not the work. It's the way the pieces are played. And it's just so.
They'll give you more words than that. They think it's. Did the calculation,
Yeah.
ready?
Okay, we need to be. Okay.
Now I'm not the whole process.
Okay. 2:15?
Probably won't be able.
Why did you think that 2:30?
Oh, why is? No, no, I wouldn't. Okay. Yeah, that's what I thought. That's why I was like, what is it? I'll see you right there. También a correr arriba y a correr a correr. No, because after I finish this, and that's why they're making me do a calendar. The person who paid the fee is supposed to be doing the Q&A. 18. 13 pages. Okay, can you take the calendar off of the best text? There she got. She received the calendar. Pages. We're gonna be here all night. Fuck. Fuck. And I'm gonna be here all night tomorrow.
Let me see how big it is. It's small for Monday. If I have all the mix, I'll bring it down.
No, she's gonna put it up for you. Go up there and talk to me. We're probably gonna need this.
Okay.
Is a 13-page calendar? Most definitely gonna need this. Page.
Trying to look for his name on this thing, but I ain't got my glasses. I was trying to look for his name. I'm in room 5. The lady said, okay, can you hear me now?
Breaking up, what you say? You trying to look for what?
His name. The lady said start at 1:30. But I ain't got my glasses on. I can't see this shit. But she said it started at 1:30. That lady was going somewhere else. Ain't nobody in this place but me. But the lady was in the front though. She said it started at 1:30. And I can't see nothing. And everybody down here seem like they're in a rush. Shit, when you trying to get some help.
They don't even be giving a damn about the people in jail. Because I've been calling TGK all morning, trying to see what's his court time and all of them people only answer their phone.
I know they don't. That's why I said when you talking to certain people, shit, they ain't thinking about this shit.
Somebody. Who the hell want to go down there to ask 1 or 2 questions?
Yeah, but they damn sure won't answer the phone. I see the name. Damn. Tars be out there doing stupid shit. I don't know why he let to walk around with a gun and all that old shit.
And I got 3 guns at my house and don't tote none of them.
Looking for trouble. If most times you got a gun, you supposed to have that permit in your back pocket.
Yeah. Remember somebody broke in his car, so he probably, if they broke his car to the door and they took that, he ain't never gonna get another one. Because he's a slacker. He's slack on everything he's supposed to do.
But you need that. That's just like your damn driving license.
Yeah. And trick time I tell your daddy, we go down there to go upstairs and tell them they could pull it. I say, them people ain't finna give my daddy that's confidential. That's him. Tourist stuff. They ain't finna give my daddy tourist business because it's short for his granddad and he want to copy his gun thing and take to the court.
Right. Okay, I'm gonna sit here and wait. All right.
Okay. Right.
Oh, not quite as bad as the mortgage. When you hear the case call for the person you're here for, let us know. And if you want to come up and speak, you can, or ask questions, okay?
Recording in progress.
Good afternoon, Mr. Marte.
Good afternoon, Jörn. How are you?
Quite fine. So good to see you.
Likewise, likewise.
Good afternoon, everybody. All rise and raise your right hand, please.
Buenas tardes a todos. Todos levántense y por favor levanten sus manos derechas.
Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do.
Dame, caballero, juran o afirman que el testimonio que van a rendir será la verdad y únicamente la verdad.
Sir interpreter, have you been sworn in today?
Yes, I have.
Ladies and gentlemen, please have a seat and thank you. Good afternoon. This is a felony bond hearing. And the purpose of this afternoon's hearing is to look at the paperwork that brought you to jail and determine if there is a probable cause for your being held in jail. And if there is probable cause, I'm sorry, Mr. Marty, let me stop there.
Okay. Buenas tardes, damas y caballeros. El propósito de la vista de hoy es para determinar si los papeles que los traen ustedes aquí contienen motivo fundado. Y si acaso hay motivo fundado, and if there's probable cause.
And if there is probable cause, to set an appropriate bond or some conditions of your release from jail.
Y si acaso su señoría determina que hay motivos fundados ante su acusación, ella podrá determinar qué tipo de fianza o condiciones podrán ustedes salir de la cárcel.
This is not a day where the court can take any plea offers in your case.
Hoy no es un día donde este tribunal va a aceptar ningún tipo de convenio en los casos que hayan en contra suyo.
I'm always willing to listen to what you want to say about your case. I just want to remind you that anything you say is recorded and could be used against you at a future trial or proceeding.
Su señoría siempre está dispuesta a escuchar todo lo que ustedes tengan que decir, pero ella también quiere decirle que toda esta vista está siendo grabada y todo lo que ustedes digan podrá ser utilizado en contra suyo tanto en un juicio como en cualquier otro procedimiento.
If you've hired a lawyer, please let me know when your name is called so I can try and locate them on the screen for you.
Es más, si acaso algunos de ustedes tienen contratado abogado privado, por favor me lo mencionan y así yo lo podré encontrar a ellos en la pantalla.
And in the meantime, for the purposes of the hearing only, I'll appoint the public defender, but we'll entertain a request to discharge them if it's appropriate.
Pero por hoy y únicamente por hoy, su señoría le va a designar a todos el bufete de abogados de oficio para que les represente y si acaso sea necesario también desechamos sus servicios.
If you need an interpreter, when you come up, let us know and we'll provide one as we're able.
Y recuerden ustedes, el que necesite un intérprete me lo deja saber y le proveeremos un intérprete si ya tenemos algún tipo de intérprete disponible.
All right, then. I'm to corrections going a little bit out of turn and I'm calling the file of Shamar Antoine Mack. Do we have with us Shamar Antoine Mack?
He's coming up, Judge.
And counsel in the jail for the public defender's office, would you like to put your last name on the record?
Yes, Judge. Madison Lang, Assistant Public Defender.
Spell your last name for me, please.
Lank.
All right, then. So thank you for joining us, and hello.
Hello, Antoine, Shamar Antoine, he got a lawyer.
And who is his lawyer?
May it please the court, I'm on Zoom here. For Mr. Mack, Jack Palmieri, Palmeri. Good afternoon to your honor, to the state, to staff.
Nice tie. Good to see you.
Your honor.
Let's see. Have you had Mr. Palmieri, and good afternoon, Mr. Mack. Have you had a chance to read the affidavit or not?
Have, your honor.
Okay, so looks like the fleeing and eluding and the reckless driving should have been handled in the misdemeanor bond calendar, and I'd imagine they've handled them there. And this court just has a carrying concealed firearm. Any argument on probable cause, counsel?
Yes, your honor. I don't believe that there's probable cause in the sense that I don't know that this charge is applicable anymore, your honor. There was a recent case that came down in Broward County. If I could, State v. Walks, WALKES, case number 25003340 Charlie Frank 10 Alpha. And it was an order granting defendant's motion to declare Florida statute 790.01 unconstitutional as it applies in that case where that defendant was between the ages of 18 to 20 years old. I believe the probable cause here in part is that Mr. Mack is under 21 years of age. However, and I think the probable cause affidavit acknowledged Florida now recognizes constitutional carry, so that is no longer an issue. And this recent case that came down on October 24th of this year now found in our sister county that the 18 to 20 year restriction is no longer constitutional. If that being the case, then the probable cause and the basis for the concealed carry violation here is likewise unconstitutional, and likewise a bond should not be held on that charge.
So are you arguing to this court that a co-equal circuit court judge in Broward County is somehow dispositive of a founding in Miami-Dade County?
I'm saying that it is setting the framework and the
can you answer the question I asked you?
I think it's creating dispositive case law. Clearly, it'll be litigated further, but I think it's worth noting.
Okay, so the answer to my question, I'll just answer it myself, is that is not controlling authority. And are you aware of the co-equal case in that same county that made a completely opposite finding?
And where there's a lot of conflicting case law, but this was, I think, the most recent one. And I just make that argument for the court.
Well, this has been an interesting argument, but one that should be raised at the trial court level. Constitutionality of a statute is typically not raised at a bond hearing. And if you wish to raise it at a bond hearing, then according to the rules, I need to have you put it in writing and give the assistant state attorney an opportunity in a week or two to respond. Did you wish to do that, or can we just march on to setting a bond?
I think, Your Honor, it's appropriate just to march on, Your Honor, given the argument I've made, given that I understand it not being fully appropriate at this point. I'd ask Your Honor to just take into consideration and to set an appropriate, reasonable bond. I believe my client's mother and girlfriend are there with Your Honor.
And he does have family in the courtroom, and we've greeted each other already.
Yes. And as you can see, they've been very diligent in hiring private counsel. So we are very serious about coming back, appearing before the court, putting a defense forward, respecting the court. And I'd ask that the court give some credence to that and just set a bond that is something the family can put together.
Judge, the fleeing and eluding charge is before Your Honor.
All right, thanks. So let's see, the reckless driving should have been handled down in county court. I do have I do have a fleeing and eluding and a carrying concealed firearm charge in front of me. Looks to me like your client has a local address and ties to the community. So let me flip to the state and see what their suggestion is on a again, I don't see any prior record at all from Mr. Mack. Anyway, let's see what the state's suggestion is on counts 1 and 2 on return of a bond.
Right. So he turned 18 in July. I do see a prior juvenile arrest involving a gun. I don't think that pretrial services is appropriate in that he fled from the police. State's requesting
In that why?
he fled from the police.
Oh, okay.
Requesting what would be the standard bond, which is $2,500 each count.
Mm.
Yeah.
And I'm just wondering, Mr. Palmer, can you tell me a little bit about your client's current probation case where he is under probation under J 25507?
I wish I could, Your Honor. I was not the attorney of record for that case. I've just been retained on this and the VOP about an hour ago. I am learning the facts of all the cases as we go. So this is all new to me as far as the juvenile case. My understanding was that it was a fleeing allegation. I was not aware, so I don't have a position if a firearm was involved, but I do not think there was a firearm charge.
All righty then. So let's see. On the count of carrying a concealed firearm, I'll set a bond in the amount of $1,000. On count 2 for fleeing and eluding, I'll set a bond in the amount of $2,500. One special condition of Mr. Mack staying out of jail is that he shall not possess, carry, or otherwise have any contact with the firearm until this case goes under further order of a circuit judge. Mr. Mack, is that something you can promise the court that you'll do?
Yes, I can.
All right. And is $3,500 total something you all folks can deal with this? All right. I will not put a juvenile probation hold on him. I'll let the juvenile judge decide what they want to do, so it won't stack him up in jail right now, right? All right, then. Thank you for your time. Any more questions? Okay.
Thank you so much to Your Honor, to the state, the staff. Everyone have a great day.
All right, Mr. Palmer, thank you for entertaining me. See ya.
You're very welcome, Your Honor.
And now I'm going to call the file of Audrey Nicole Timmons. That you, Miss Timmons? All right. Good afternoon. It looks like you're charged on November 6th with allegedly car theft automobile. Any argument from you, Ms. Lank?
No PC arguments.
All right, probable cause is found, and now let's see what we can do to set a bond or release.
So the defendant was sentenced to 6 years in state prison for kidnapping, burglary, carjacking. That was out of Broward County. She was released in 2023. The state is requesting a bond. Additionally, she's got more recently 33 days from December, and there's an open misdemeanor.
I'm curious then why, because the case you're quoting to me is an out of county conviction?
Yes, it was out of Broward County.
Ms. Lank, you want to talk to your client a little bit about the state's claim that she was convicted of some kidnapping and served some time?
Let's see if I'm going to try and screen share again. I don't know if it'll work.
Miss Seth, are you saying it's an open case right now or no?
No, she did 6 years in state prison. She was released in 2023.
Okay, Judge, this is obviously something totally unrelated to her prior case. She's accused of having a car that apparently she borrowed from her friend Robert that day earlier to go get to pick up her medications. Looks like it's the same day, Judge.
She does have a place that she can stay. She has an address, so we are going to ask for PTS.
Well, let's see. Police report for a stolen vehicle. Borrowed the car. Went to New Horizons. and no current address. Client, can your counsel, can your client make $1,000 bond?
Yes.
Okay, I'm going to set bond in the amount of only $1,000 in this case, given the circumstances, and we'll go from there. Next up, I'm going to call the file of Maxine Walker.
Miss Walker may qualify for TAP.
Judge, Mrs. Walker is NBC Medical.
We can reset it for tomorrow.
Reset till tomorrow?
She's here.
Oh, no, I must not have heard things correctly. Hi, Miss Walker. It looks like you're charged with 1 count of possession of crack and 1 count of possession of fentanyl. Probable cause argument?
No probable cause argument, Judge. We were going to ask for TAP.
Probable cause is found. Miss F,
TAP's good.
Consider TAP with alternate bonds and a specific court date. Want to object?
I don't.
TAP. So that means, ma'am, that I'm going to ask the alternative program to get you out of jail and help supervise and get you back to court on the correct date. We're now going to give you a court date and a courtroom, and you'll need to get yourself back to the courthouse. Is that something you think you can do? All right, then TAP alternate bond in count 1 and count 2 is $1,000. Let's get that date in place, please. Yes.
The court date will be 12/8.
Your client will need to be back in court on December 8th. And whose court will it be? Alberto Milian. His courtroom will be up on the 7th floor to the right when you get off the elevator. So you'll be looking for Judge Milian on December 8th up on the 7th floor. Okay? Alejandro Brito.
Ms. Brito is out on felony bond F-25.
15163. Thank you. Good afternoon, ma'am. It looks like you've been now arrested for possession of drugs and possession of drugs without a prescription. And I think it looks like Judge Rodriguez had let you out on felony bond. And when that happens, one of the conditions of getting out on felony bond was that you not get arrested again. And it appears that you violated that. So I'm going to put a no bond hold you on 25-16163 and send you to see Judge Rodriguez on Monday. In the meantime, probable cause is found. Bond on count 1 is $2,500 and bond on count 2 is $150.
Count 1, 2,500, did you say?
I did.
Okay, thank you.
No problem. Now I have a file for Reynolds Lachey Katrina.
Bond out.
Next up will be Kenya Weaver.
There may be a private attorney present. Miss Corey, I'm not a co-host. Do you mind promoting?
I'm sorry, Ms.
Can you promote the private attorney for Miss Weaver, please? I'm not a co-host.
Of course.
Do we have any lawyer on screen? Hi, Miss Weaver, be right with you. Any lawyer appearing on screen for Kenya Weaver?
Mr. Raven is joining.
I don't see anybody in the Zoom thing. Gallery view. Gallery, everybody. Would that be Mr. Wabin?
No, that's Mr.
Oh, well, such a nice picture of him.
Yeah.
Anybody else?
The defendant. No.
Mr. Raven is here.
I am here, Judge. Good afternoon.
Afternoon. We're looking for counsel for Kenya Weaver.
That's me, Judge.
Would you like to be that lawyer?
I would like to be that lawyer, Judge, and I appreciate that very much. I also on Zoom should be the victim in the case, Michael O'Brien, if you could let him in as well.
Okay. And where's my Harry Potter wand when I need it? Oh, yeah, mercy, sort by, hide self, hide, show, pair. There we go. We have another name appearing on screen. And to the other folks who are co-hosting, thank you for helping me move this along. Anyway, have
All
your
right.
Mr. Wavy
Judge,
opportunity to read the arrest affidavit.
Okay. Let me know when you're ready. I'm not going to be making a
Ask you
probable
if
cause
you had
affidavit.
a chance to read the arrest affidavit yet.
Yes, Judge, I have.
Thank you. All right, I've read the arrest affidavit. Any argument on probable cause?
No, Your Honor.
All right, probable cause is found. Now let's talk about setting an appropriate bond.
Judge, I would ask for a straight bond and a low bond. She's 24 years old, never been arrested as far as I'm advised, has lived in South Florida her entire life, is gainfully employed, was in a relationship.
Do?
I'm sorry?
What does your client do?
She is a DoorDash driver and has done that for 3 years.
Okay. I interrupted you when you're telling me she was gainfully employed.
She is indeed. The victim in this case, Michael O'Brien, wants her to be released. He wants to court to allow peaceful contact between the two. And I would ask for a bond of $500 or $1,000 to cover both charges. I think that's sufficient.
Before Your Honor sets a bond, can we hear from the victim?
Did you wish to speak with Mr. O'Brien for a moment, Ms. F?
Oh, no, I don't think I need to, but if you're, I don't know if he's requesting a stay away order. If not, then we may need him to testify as such.
He is not requesting a stay away order. And Mr. O'Brien, can you unmute your microphone so you can talk?
All right, Mr. Raven, if I may be so bold as to speak. Mr. O'Brien, it is up to the state attorney's office to decide if they're going to go forward with charges or not. So that's not something that can be managed or dealt with today in court. My question for you is simply, do you want me to prohibit Ms. Weaver from having contact with you, or do you want me to order no violent contact? What are your thoughts about this?
I'm sorry, could you ask the question again to make sure I understand your question properly?
How do you feel about usually a court enters an order in ordering a defendant to usually a court will say a defendant is prohibited from having any contact, direct or indirect, with the alleged victim. Is that an order you would like me to put into place or not?
No, Your Honor.
All right, then my second alternative, which I consider, is to allow contact, but require that it has to be a nonviolent and civil, appropriate type contact. Is that something that you would prefer in this case?
Yes, Your Honor.
Contact, but no violence.
Yes.
Okay. Ms. Weaver, when somebody has the type of charges that you picked up in this case, I have to put some conditions of release in, and I'm going to read them to you now. As a condition of being released from jail because you're charged with domestic violence, you in the future cannot engage in any criminal activity. If you got arrested for something else, that would revoke your bond or release, and you cannot use or possess any illegal drugs. Do you understand that so far?
Yes, I do.
Okay. You cannot use, possess, purchase, or carry a firearm, gun, weapon, or ammunition. If you have any firearms, ammunition, or concealed weapons, you must surrender them to the nearest police department and file a receipt with the court. And that would be your responsibility in terms of firearms. Do you understand that, ma'am?
Okay.
And You are prohibited from having any type of violent contact with Mr. O'Brien. At the time of this incident, were the two of you living together, Ms. Weaver?
Yes.
All right. Whose house was it? Yours or his?
Michael's.
I'm sorry? Michael's. So you may return to that residence one time within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal belongings, like, clothing, medications, any kind of paperwork and tools. You can do that one time within 48 hours, but you'll need to contact the police department to accompany you to do that. And you two have no children in common?
No.
All right, then I won't talk about child custody. So that is the stay away type of order I've entered. And on the domestic violence charge, I'll enter a bond of $500. Given Mr. Rabin's arguments in the case on count one, instead of a standard bond of $5,000, I'll put in a bond of $500. So count one is 500 and count two is 500. Is that something you believe you can assist your client making, Mr. Rabin?
Yes, Judge, they will be able to handle that.
All right. Well, thank you for appearing this afternoon. Anything else, Mr. Rabin, Mr. O'Brien, Ms. Weaver?
That's it, Judge, and thank you very much for your courtesy. Have
All
a good
right.
day.
Thank you.
Bye-bye.
Thank you.
Let's see. A, S, S, and N. Here we go. Done, and done. Next up, we have the case of Heather Lindsay.
Ms. Corbett trying to get her into the hospital. Any luck on Miss Lindsay?
Should have a defendant on Zoom, Mr. McIntosh from pretrial. May we take him, please?
I'm finding McIntosh Jones.
Last one on the count.
Got it.
This is an added charge.
Uh-huh. Probable cause is found. Bond is $1,000.
Mr. McIntosh, you have a new charge for tampering with physical evidence. The judge just set a bond of $1,000. Your public defender will be talking to you soon about your charges, okay?
Okay.
Thank you, sir.
Thank you for your time, sir. Now, if it's okay, I'm going to flip back to Heather Lindsay.
Ms. Quarters, does she have benefits for the hospital?
Not have active benefits at this time.
So your Honor set a $500 bond this morning.
Court having probable cause, then the bond in this case is $500.
Corrections, once you get on our bench warrant?
There was a
Gave a one
bench warrant issued on October 16th of 2025, a misdemeanor petty theft case.
And corrections, you got a $1 bond on that?
$1.
Judge, would you consider TAP and including the bench warrant too?
No.
I think your Honor did consider it this morning.
No. Let's see. Got arrested for petty theft, was asked to come to court, didn't come to court, got a warrant, and got arrested again. No. I'm comfortable with the bonds I've set, but thank you for having me reconsider it. Coming up next, Carlos Rodriguez.
Mr. Rodriguez, Judge, is NBC detox. Reset for tomorrow.
Reset till 11/8. Calling the file of Dimitri Spencer. Is that you, Mr. Spencer?
Yeah.
Okay, it looks like you got arrested for possession of cocaine within 1,000 feet of a gas station convenience type store and resisting an officer without offering to do violence and petty theft and drinking some alcohol in public. Anyway, let's see if Ms. Lank has any argument on probable cause.
So Judge, I'm going to agree just possession on count 1.
Plead to big law.
Yes. Yeah, there's only probable cause on count 1 for possession, so the church enhancement or the convenience store enhancement wouldn't apply. So we're gonna ask for pretrial services. He has an address to stay at.
So that address on the A form is the Homeless Assistance Center. The defendant does have an open misdemeanor for trespass. I also see a conviction for trespass from July, a 30-day sentence for disorderly conduct from June. State's requesting a bond.
Can we do tap, Your Honor?
No. No. So, Mr. Spencer, I'm going to set a bond for you in count 1 of only $500, given your lawyer's argument. Count 2 is $500, and count 3 and 4 are only $150. When and if you are released from custody, I am ordering that you cannot go to the On the Run gas station at 1650 Northwest 20th Street again. You need to stay away from there in the meantime. All right, thank you for your time. Now I'm going to call the file of
Judge, he indicates he can't afford the bond. Would you rather consider the tap only?
I thought about tapping. That's a no.
And please, yo.
Calling Kataj Hodges. Mr. Hodges, it looks like the arrest affidavit claims that you're in possession of MDMA and allegedly tampered with physical evidence and possession of some marijuana. So let's read this. Riding a bicycle, threw a baggie on the ground. Man. Okay. Anyway. Looks like you have an arraignment coming up next month for retail theft, and then another arraignment on a petty theft, and then another arraignment on the third petty theft case. So I'm thinking you might have been out on felony bond at the time of this arrest. In all 3 of those cases, or on some form of release. So to the state, am I looking? I'm thinking
The defendant is out on felony bond on 3 separate felony cases. The state is requesting a hold.
And those have not been reduced to misdemeanors?
I don't think so.
No, it's petty theft, 2 or more convictions. Well, phooey. So Mr. Hodgson and Ms. Lank, I will, of course, set bonds on the new cases, but I'm going to put a hold in on the cases that he was already released from jail on and have him go see the judge who issued the bonds in cases 25-21938, 25-21940, and 25-22149, because one of the conditions of your getting out of jail was that you not get arrested again. And golly, looks like you have. So that's a no bond hold on those 3 case numbers. Go see the other judge, see how they feel about it. And I'll be setting a bond in count 1 of $2,500 and count 2 of $2,500. And on count 3, it's marijuana, so just $1. All right then, thank you.
Judge, how much was count 1?
What?
Count 1.
Count 1 was 25. Count 2 was 25. Count 3 was 1. And let's look at Kobe Anderson. Is that you, sir? All right. It looks like you're out on felony bond with Judge Jean, and you got arrested for a
Which
burglary.
I don't think so. I think maybe the sticky was for the previous case.
Correct. That's for Mr. Hodges, who you just called. They just printed out above Mr. Anderson's case. It does not apply to him.
Yeah, I was just thinking that looks like Hodges' case numbers. So I'm going to pull that sticker. Good thing staff is paying attention. Anyway, Mr. Anderson, it looks like on November 6th, you're charged with allegedly committing a burglary of an occupied conveyance and criminal mischief. Let's see if there's probable cause or not. Yeah. Any argument there, Ms. Lang?
No PC arguments, Judge.
So I think there's PC. I don't see any criminal history. If he's got somewhere else to stay, maybe a program.
Of all that you said, all I heard was history.
So right, there's PC. I see no criminal history, and if he has somewhere else to live, he may qualify for a program.
Thank you. Might be the sound is bouncy in your room. Could be I'm going deaf. So
Can we do PTS, Judge?
The victim does not.
The victim does not live with him.
Looks like pretrial services has indicated your client, Ms. Lang, does not qualify.
Would you order?
Would you order him in?
Why don't they qualify? It's the charges, right? Pretrial? Your Honor doesn't mind asking in court.
It's a car. Okay, it's the nature of the charges because the automobile was occupied.
I think he took grabbed a bag containing the computer and his water bottle from the car.
Got it. So,
Judge, sorry, we actually do have a probable cause argument for count one. It doesn't say, it's not clear whose stuff he's taking, if it's his or if it's the other person. So it should really be a trespass, if anything.
let's see, while the victim was seated inside his vehicle, the defendant entered the vehicle without the victim's consent. And while in the vehicle, grabbed his computer and a Stanley water cup from inside the vehicle and exited. The victim then attempted to retrieve the items by physically grabbing the defendant, which escalated into a altercation. Sounds like probable cause to me. Let's see, counsel. If I lowered the bond down to like $2,000 on count one, is that something you think your client might be able to make?
Yes.
Okay, and I will do that. Now, Mr. Anderson, you'll be, when you make the bond and get out of jail, there's some pretrial release conditions you have to follow. You cannot engage in any criminal activity. You can't get arrested for something again, or you'll get held. You cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry like a firearm, gun, weapon, ammunition. If you have any of those or a concealed weapons permit, you'd need to turn it into the nearest police department. You're at this time prohibited from having any direct or indirect contact with Renee Noah Jr. This means in person, in writing, by telephone, social media, and you must stay away from this person at all times and stay at least 500 feet away. And you two were not living together at the time? Okay, then, so those are going to be some of the conditions of your release that you'll need to follow. I will set bond in count two in the amount of $1, and in count one, I will lower the bond down to $2,000. As your lawyer has told me, she thinks that you can make that amount of bond, okay?
Judge, would you make it a non-domestic since they've never lived together? It should not be a domestic violence.
Hey,
I mean, the officer marks it as DV, I don't know.
okay, let's see.
Then he went to the alleged victim's location, where the victim
Made contact with the defendant who states he had been involved in a relationship with the victim for approximately 2 years. So you're arguing that what?
dating is not enough, Judge. They have to have resided together at some point, which they never have. And it's clear from the arrest form that they had 2 different home locations. Mr. Anderson's on the arrest form.
I've never heard that argument.
Add-
So let me take the time and read Florida Statute 903.407.
So Judge, Miss Corey's correct. It goes
Don't worry,
into
we could be here all day.
it goes into the definition of domestic violence, but I don't know if the victim's going to say that they lived together at some point and the officer wrote it as domestic. So I'm asking that Your Honor leave it.
Look, they're still talking. Let's see. Well, I'm gonna regretfully inform the defense that I disagree with their position on the court's order. Any further access you need to the record before I sign it?
Yes, Judge. Under domestic violence statute 741.28 subsection 3, family or household members. Spouse, former spouse, persons related by blood or marriage, persons who are presently residing together as if a family or who have resided together in the past as if a family, and persons who are parents of a child in common regardless of whether they have been married, with the exceptions of persons who have a child in common. The family or household members must be currently residing or have in the past resided together in the same single dwelling unit. This case does not apply as there's no allegation that they have ever lived together. In fact, the arrest form indicates clearly that they have 2 separate residences.
Any further access you need to the record?
No, Judge, that's it.
All righty then. So, set the bond in your case, and I've ordered you to stay away from Robert Noah Jr. until we can get the case a little bit further down the line resolved, okay? All right, good luck to you then, sir. Now I'm gonna call the file for a Heather Lindsay.
Judge.
No, I don't know why that got tucked in there, sorry.
Judge, what's the bond?
Count 1, 2.
So count 1 and 2.
It was 2,000 on count 1 and $1 on count 2 for this gentleman. Now I have a file of Janelle Rogers.
He's a violent felony offender, special concern.
Mr. Rogers, you were arrested yesterday for 1 count of possession of cocaine within 1,000 feet of the church and tampering with physical evidence and possession of drug paraphernalia. Let's read the arrest affidavit.
So I'm only asking the court to find probable cause as to count 1 and count 4. Count 1 would be possession.
I agree.
So, 2 counts of possession, 1 count of tampering, and 4 counts of possession of drug paraphernalia. And I think the state is suggesting to the court that I should only find 1 count of possession of drug paraphernalia. Is that what I'm hearing?
So 1 count of possession of cocaine and 1 count of possession of drug paraphernalia. That would be count 1 and count number 4.
Got it. And as far as the tampering, can I still look at that or not?
I don't think there's PC on it. I think, what was it? They asked him if he had anything else. He said no, and then they found other stuff.
That's one more time.
Judge, he wasn't even detained. It was a consensual encounter. I'm thinking of the right one. Yeah. So he wasn't trying to destroy anything. He was just moving something in his pocket during a consensual encounter. So there's no PC for tampering with evidence.
Okay. Count the counts. Count 2 is a no PC or release outright. Count 3 is a no PC release outright. Count 5 is a no PC release outright. Count 1 and count 4, however, there is probable cause. Count is drug paraphernalia. Count 4, the bond is $500, and count 1, back to the possession of a controlled substance state. Please feel free to make a suggestion on the bound amount, then we'll hear from the defense.
Requesting standard 2,500. The defendant was released from jail. He finished at 364 on October 23rd. Also, corrections is saying he's a VFOS, but I'm not sure.
Okay, and from the defense?
Mr. Rogers is homeless, so we wanted to tap for him. He can't afford any bond.
Okay, I'm going to set the bond in count 1 in the amount of $1,000. And then count 4 was 500 with the other counts released outright.
Count 6 and 7, Your Honor?
Yes, it's outright. Thank you for the reminder. I did not write that down. And on to the next file, which should be Alan Ollie.
He's on felony bonds.
Oh, no. Well, Mr. Colley, it looks like you're arrested for allegedly being in possession of suspected cocaine and gambling. Oh, goodness gracious. Any argument on the probable cause, counsel?
No probable cause, Judge, but we did want to get an ROR on the misdemeanor gambling because
That's fine, or $1 since he's being held anyways.
So, I guess I'll just jump in with the bad news. Or talk to myself. Okay. Mr. Colley, you had been already released from jail on a bond, and one of the conditions of your being released on the other case was that you not get arrested again. So there is a no bond hold on 25-23057. We'll set your case Monday in front of that judge so they can review whether or not they want to give you a new bond on the old case. On the count 2 of gambling, I will put in a release outright, and on count 1, possession of cocaine, I'm going to set a bond in that case of $1,500. Christopher Aaron Fletcher.
He was given pretrial services on his traffic case.
Okay, thank you. Mr. Fletcher, you're charged with allegedly being in possession of a controlled substance and possession of drug paraphernalia. And Padded down pocket pipe meth suspended license. Alrighty then. So, hearing no argument to the contrary, probable cause is found.
Just on possession as to count number 1, Judge. And I believe he would also qualify for pretrial.
Say what? To the state, maybe I'm missing something, but I'm wondering
Maybe
how
I
this
am.
was charged as possession with intent.
I'm stipulating to simple possession.
Yeah, simple. All right then, PC, so I'm gonna find probable cause, count 1, possession, simple possession.
So it was residents.
Count 2 is drug paraphernalia, and there is probable cause on that. So I'm going to order pretrial services, alternate bond in count 1 of $1,000, alternate bond in count 2 of $500. A special condition of your staying out of jail on this is no drug possession, and do not drive without a license. Your license is suspended. You cannot drive an automobile without a license. And so that is also a special condition of pretrial services getting you out. Do you understand?
Do you understand?
Your head is bobbing up and down. Is that a seizure, or are you agreeing with me?
I agree.
Okay. You gotta quit digging the hole any deeper than it is, but okay then. So that work is done. Next up, we have, let's see, Rafael Valestevez. Good afternoon. It looks like you're arrested for allegedly committing an aggravated battery with a weapon. Give us a chance to read this.
Necesito intérprete, caballero.
In the hospital, intubated with a brain bleed. My goodness. Oh my goodness. This says alleged to have happened on November of 6th. I'm wondering if there's any argument on probable cause. No? Okay, probable cause found. And would the state carrier be heard on what an appropriate bond should be?
Requesting no less than standard.
Which is,
15,000 on an F1.
let me go to Ms. Lang. Or Ms. Curry, or anybody.
But we do want to, on the record, invoke his rights to counsel and the right to remain silent.
Okay. Yeah. A condition of your getting out of jail will be there's set a bond of 15, and there are some other conditions you're going to have to follow. You cannot engage in any criminal activity. You cannot use or possess any illegal drugs. Do you understand that so far?
Need Spanish, Mr.
An interpreter?
Oh, dear God. You know,
I suspect
very
that you're-
useful to tell the court that at the beginning, so I don't have to start all over again, but let me start.
Your Honor, I wrote it down. I thought, okay. Señor, usted se le acusa de agresión corporal con agravantes con un arma mortífera. Inclusive la víctima parece que está intubada con algún desangramiento en el cerebro. Además, su señoría le preguntó a la fiscal adjunta, a la doctora Ed, que qué tipo de fianza. Ella dijo que mínimo fianza de rigor. La fianza de rigor son $15,000. Standard bond, 15,000. After that, I don't remember anything else.
Dear Lord, Mr. Marta, you're good. Also, you cannot, if you get out of jail, you cannot use, purchase, or possess, or carry a firearm, gun, weapon, or ammunition.
Inclusive, si usted puede salir de la cárcel, usted no podrá usar, portar, ni comprar, ni poseer arma de fuego, municiones, ni arma blanca.
You must immediately surrender any firearms or ammunition or concealed weapons permits to the police department and file a receipt with the court.
Inclusive, si acaso tiene arma de fuego o quizás tiene licencia de portar arma oculta, la tiene que entregar al destacamento o comisaría policial que más cerca le quede y luego ese recibo lo tiene que entregar a los escribanos.
You are prohibited from having any direct or indirect contact with Rafael Valdeslee.
Valdeslee? Okay.
Valdeslee.
Thank you, thank you. Y usted se le prohíbe tener cualquier tipo de contacto con el señor Rafael Valdeslee.
You cannot contact this person in writing, by phone, through social media, or through third parties.
Usted no se puede comunicar con esa persona ni por escrito, ni por teléfono, ni por medios sociales, ni a través de terceras personas.
You must stay at least 500 feet away from the alleged victim in this case. They're where they live, where they work, or where they might go to school.
Y además, usted tiene que mantenerse mínimo a 500 pies de distancia de la supuesta víctima, de donde él viva, de donde él trabaje, o si él va a la escuela, de la escuela donde él vaya.
You may return to the residence one time only within 48 hours of the entry of this order.
Usted podrá volver a esa casa una sola vez con un periodo de 48 horas en menos, una vez que salga de la cárcel, con una copia de una orden que su señoría le va a firmar a usted.
Accompanied by a police officer to retrieve your personal belongings.
Usted tendrá que ir ahí con el acompañamiento de un agente policial para recoger sus efectos personales.
Going to the home or remaining at the home without the police will subject you to arrest.
Señor, si usted va a la casa sin los agentes policiales o se queda en esa casa sin los agentes policiales, usted terminará arrestado de nuevo.
If you have any keys or garage door openers or things like that to access the home, you must turn them over to the police.
Es más, cualquier llave que usted tenga para ese hogar, o quizás si tiene algo para abrir el garaje, un abridor automático, se lo tiene que entregar a la policía.
Do you understand the conditions of the pretrial release order that will accompany your getting out of jail?
Señores, ¿que acaso usted está entendiendo las órdenes que ella le está dando por si acaso usted sale de la cárcel, esa orden de alejamiento? Caballero?
Sí, sí.
Yes.
Probable cause having been found, the bond is set in this case in the amount of $15,000.
Su señoría ha determinado que este caso tiene motivos fundados y la fianza es de $15,000.
Calling about Eduardo Araujo.
Reset disruptive, Your Honor, for tomorrow.
Reset till tomorrow. Reminding that we need to make a note that he was already out on bond on 25-12897.
Yes, replacing the whole.
Judge, who did you call that you're resetting?
It was Araujo or Rujo was.
That was Eduardo Araujo. Araujo.
What happened to him? Why isn't he here?
Disruptive.
What?
Disruptive.
Oh, well, sometimes you just have a bad day. Calling Ulrich Christian.
Ward D, reset for tomorrow.
Ward D, reset till tomorrow. Be right with you, sir. And let's see, are you Gio Alfonso?
Yes.
Okay, Mr. Alfonso, it looks like they've added some charges of allegedly committing a battery on a correctional officer yesterday. Let's see what we have here. This looks like there's a battery on a law enforcement officer here when there's probable cause for it. And Let's see, at the time this happened, I'm wondering if you might have already been out on a bond. So it looks like you had been out on bond on a felony case for allegedly committing a battery on a medical care provider. I'm gonna interrupt you and see if you wanted to talk with your lawyer about this. It looks like I have 24-10765 and 24-10766 that you had been released from custody on.
He's on felony bond in those cases.
Yes, indeed. So, I know Judge James is gonna want to talk to him about the new charges. So there's a no bond hold on the 10765 and 10766 on this battery charge. There is probable cause found, and I'll set a bond in the amount of $1,000. Yes, there was a. And calling now the file of Antonio Martinez.
Bond out.
Next up will be Trevor Stevens. Let's see, Mr. Stevens, it looks like you're charged with allegedly committing a battery on a law enforcement officer and resisting an officer without offering to do violence, something in relationship to a hit and run accident on 79th Street. So let's read this paperwork here. Any argument on probable cause? Okay, probable cause found. Now let's talk about bonds or releases. Let's see. Count 2, the bond is a standard above $500. Okay, I'll just write it in myself. And count 1, the battery on a law enforcement officer. Any argument from request from the state, and then go to the defense.
I mean, it's connected to a DUI. State's requesting standard bond.
And the standard bond on a bat Leo is
5,000.
so, okay. And
do 25,000, 2,500.
So the bond in count 1 is 5,000. The bond in count 2 is 500. Well, goodness. Now I'm going to call the file of Aaron Lipscomb. Be right with you, Mr. Lipscomb. All right. Any argument on probable cause?
No argument.
All right, probable cause is found. Let's see, count 3 is the marijuana possession. I'll enter a bond of $500. Let me return to the state. Let me ask you a question. Count 1 is possession of firearm while being a convicted felon, and count 2 is carrying a concealed firearm. I'm wondering if the short court could consider bond on both those counts, or whether count 2 might be presumed under count 1. What are your thoughts about this?
It's not, Judge, because both crimes contain different elements. Count 1, there's a requirement that the defendant's a convicted felon. Count 2, it needs to be concealed.
So not subsumed under count 1 then?
Correct.
All right, let me turn over to the, and if, as the court sets bond, what is your suggested request on balance for counts 1 and 2?
Standard bond, which is $7,500 on count 1, 2,500 on count 2.
Well, let me go to the defense and find out what your thoughts are on the matter.
Could we split the bond and do 5,000 on count 1 and 2,500 on count 2?
All right, the bond in count 1 is $5,000. The bond in count 2 is $1,000, and the bond in count 3 is $500. Calling your lips. I just did. I'm so sorry. The next file is Dayon Boykins. Mr. Boykins, it looks like you were allegedly charged with fleeing and eluding a police officer, and it looks like you're also out on bond in felony case 25-16145. Let's see if there's probable cause for this arrest.
So, Ms. Corey, this is a little tricky. This is a little tricky. I think that the case that he's out on felony bond for is the same facts as this case he was just arrested on. Because if you look, this occurred on July 7th.
Yep.
And I checked out the information on the case that he was arrested on, and I think that's also.
So what I'm thinking then is that the arrest yesterday should not violate the bond conditions in 25-16145 then?
Yes, and in addition, it could be duplicative if he's already been arrested for fleeing and eluding.
Okay.
Different.
So I'm wondering then if this should be a release outright, send it to division and go from there?
Sounds good.
Yes. Ms. Court, did you find the same thing, or is this new to you?
He's also in custody on a misdemeanor, improper exhibition of a weapon and resisting officer without violence.
Not
So that, right. So that may constitute a hold, but not this felony case.
So I'd imagine the misdemeanor judge would have dealt with that appropriately. And on this case, 25-24293, there is a release outright.
And no hold on F2.
No hold on this one. The facts occurred back in July, so this arrest would not flip back to the July bond. I have a file for Anthony Shannon. Hi, Mr. Shannon. It looks like you got arrested for allegedly being in possession of a controlled substance, and you are out on bond on felony 25-20184. There's probable cause for the new arrest. I will be glad to set a bond in the amount of only $1,000, but there's a no bond hold on 25-20184 because a condition of that release was that you not get arrested again. So we'll send you over to see Judge Block on Monday and let him talk about the new arrest and the old bond.
1,000, Your Honor?
Yes. McTorris Dixon. Huh. Promethazine. Promethazine. That's interesting. Are you here for Mr. Dixon?
Yes, ma'am.
Okay, hello.
That's my grandson. That was his wife was sitting there, got a baby from him.
Oh, well.
But they had to go pick up the
Present for Mr. or Taurus.
Well, good afternoon, Mr. Dixon. It's alleged that on yesterday you were in possession of a controlled substance while armed and one count of possession of marijuana. So let's read this A form. Firearm in the glove box. Marijuana in plain view on your lap. A clear baby bottle containing suspect promethazine mixed with juice in the center console cup holder. All right then. Any argument on probable cause? No? Okay. Probable cause is found. Now let's talk about bonds and releases.
In the car, Judge.
I'm sorry, what?
There is nothing in the A form that alleges that he knew that there was a gun in the car.
Well, let me back up again. Let's see.
It's the defendant stated that his firearm was in the glove compartment of the vehicle.
Huh. So let's see. Made contact with the driver, and the driver stated that his firearm was in the glove compartment of the vehicle. I'm thinking that kind of contradicts the argument you might have just made.
The arrest form looked like the driver's last name was Hiraby, but it's hereby because they.
Yeah, I don't think Mr. Hiraby was in the. I understand your. Mr. Hiraby was not in the car. Anyway, so probable cause is found. Now let's talk about setting a bond for armed possession of promethazine.
But for that gun, he got a license for that gun.
Oh, good. That will be something that will be helpful for his lawyers. Anyway, let's talk about a bond. No bond? Okay.
I think pretrial is okay, Judge.
So count 2 is marijuana possession. I'll set bond in the amount of 500. And Miss F, I didn't quite.
I think pretrial is okay.
What?
Is he eligible for pretrial?
Okay. So I'm gonna. Mr. Dixon, age 24, and is Ms. Lank, is your client working at this time?
He's in the labor pool, like this.
No, Liverpool is how you show. How you it's called how you like every day $10.
He's employed.
They were.
All right. Pre-trial services. Alternate bond in count 1 is $3,000. Alternate bond in count 2 is $500. So I'm asking pre-trial services to get Mr. Dixon out so he doesn't need to pay a bond in this case, okay? Thank you. Are there any questions you need answered?
So what I need to do now? Is they gonna let him out, or where will they let him out?
The answer to what you need to do is once you have a seat, when court is over, you can talk with our people from pretrial services and they'll help you get your question answered, okay?
So, sir, it's going to be a few hours. You should wait for a call from him.
Now I have the file for Antoine Williams. Be right with you, Mr. Williams. So you've been picked up one count of grand theft of a firearm and one count of carrying a concealed firearm and one count of possession of marijuana. Any argument on probable cause? Okay, probable cause is found. And
Sorry, Judge, we actually do have we do have a probable cause argument. The gun was stolen in 2023. It's too remote to actually make that connection.
huh, interesting. Let me read it again.
Right, and knowledge is an element of the crime. It's not recently stolen. I'll agree to $1 as to that count.
I did not catch the 2023 dates on my first read through. So good job. On count one, I'm going to find no PC and a release outright. On count two, however, there is probable cause and a standard bond would be $2,500, and on the marijuana charge, a standard would be $500. Any reason that should not just be the end of the case this afternoon? No.
Judge, can we do pretrial services?
Hmm.
He's with his mom and he's applied to the job court.
I don't know, he just had a weapons charge dismissed a week ago.
Yeah, about 2 weeks ago.
It was dismissed.
I don't know if he completed a program or why, but now he's in possession of a gun and it's stolen.
I'm going with the standard bond in this case. Count one was a release outright. Count two is $2,500. Count three, since it is marijuana, I'm going to reduce the bond to $1. So no bond. Count one, it's been a release outright. Count two, 25, and count one, $1. Let's see. How is that driving around with marijuana and guns working out for you? Probably something you may want to back off from at the moment. Abelson, Mirabel. Let's see, an outstanding warrant for, let me guess, driving with license suspended or revoked. Leaving the scene of an accident. Those have probably all been dealt with. So, it looks like many of these counts have the resist. No, I'll be here. So it looks like you're charged with allegedly fleeing and eluding a law enforcement officer and resisting without violence and driving with license suspended or revoked and leaving the scene of an accident with property damages. May I ask corrections? Were counts 1, 3, and 4 addressed in misdemeanor court? Or
the two traffic cases and the bench warrant were addressed. He received the bonds, total bond of $1,151.
So the counts this court has remaining are
the fleeing and the resisting.
Got it. So we won't touch the DWS or the LSA at the moment. Let's look if we have probable cause for the other two counts. To the state, can you point me to the language in the arrest affidavit which would support the resisting without violence charge?
A brief foot pursuit ensued. The defendant was placed in handcuffs. Further incidents post resisting multiple commands to stop running.
So can running constitute resisting without violence?
Yes, if the officers tell him to stop and he runs from the officers after bailing from the vehicle.
Wait. Yep, Judge, can we split the bond between the two counts?
And I do what?
Split the bond in between the two counts of fleeing and eluding and resisting without violence.
And what does split the bond between two counts mean?
So it would be 2,000 and 500 for counts 1 and 2.
Oh, okay. Well, let me quit examining my own probable cause argument and find probable cause. Bond in count 1 is $2,000 and the bond in count 2 is 500 as requested by the defense. Okay, then. Calling Emmanuel Jackson. Good afternoon, Mr. Jackson. Looks like you're charged with allegedly being in possession of some methamphetamine, controlled substance and resisting an officer without offering to do violence. Any argument? Probable cause? Okay, probable cause is found. Let's see what we can do in terms of bond or release.
Say what the drug is.
So 2 options. We can reset this for PCH tomorrow, or if counsel's willing to, we can stipulate to probable cause and do TAP today.
Can we do pretrial? He has an address.
I don't think they're going to take him with his history.
Let's give pretrial services with an alternate bonding count 1 of $2,000 and count 2 of 500.
Your Honor's probably gonna have to order him in.
What? Oh my goodness, I didn't hear that.
Would you order mention?
We're on Emmanuel Jackson.
No.
So I was calling him. Pretrial services won't touch Mr. Jackson because the amount of prior arrests that he's had. So pretrial services is not an option.
Could you order him in, Judge?
Nope.
No.
Then TAP or the PC hearing. What do you want to do?
So I'll reduce the bond in count 1 to $1,000. The bond in count 2 is 500.
Judge, if counsel is willing to waive the issue, would you do that as an alternate to TAP?
All right, if that's what folks are asking for, the alternative program, alternate bond in count 1 is back up to $2,500 and alternate bond in count 2 is 500. And the TAP program. Sebastian Valentino was reset to this afternoon.
Mr. Jackson, would you just set a total bond of 1,500 with no TAP? Because TAP is already gone for the day. You'd like to see it. Wait a bond up.
So I'm sorry, you want me to recall the file I just handled?
Yes, Judge. Well,
Here. Let me recall the file. Having recalled the file in the case of Mr. Jackson. Let me scratch everything out and start over again. Count 1, the bond will be $1,000. Count 2, the bond will be $500 with no TAP. No alternate program, just those two bonds on count 1 and count 2. All right. Now, back to corrections. May I ask you if Sebastian Valentino was able to be brought to court this afternoon? Or not?
NBC, you're on the reset for tomorrow.
Okay, we'll reset again till 11:08. And we have a file for Gerald Almora Sierra.
I refuse, court order.
Probable cause is found. I'll set bond at $1,000.
You're waiving this present.
I am.
1,000. Miss F, you have the name of the alleged victim?
It is Peyton Pierre.
Thank you.
Calling up Raymond Balous. This is an afternoon reset, and let's see, he refused yesterday, and
He was in circuit court this morning. Corrections, is a jail card still with yes. Court? Reset for tomorrow.
Reset till 11:08. And I have a file for Jakari Hardaway.
He also is in circuit court. Reset for tomorrow.
And we'll reset that to 11:08. To corrections, is there anything else you need to have us call before we sign off for the day?
No, that's it. Thank you.
All right, thank you so much.
Thank you, Judge.
It was nice seeing you, Judge. Have a good weekend.
All right, see you next week.